All right. Good morning. This is the January 12, 2024 meeting of the Committee on Professional Responsibility and Conduct at the California State Bar. I think the first thing we should, remind everyone that this meeting is being recorded and we should take roll.
Okay, I will take the roll. Vanola?
Here.
Riley?
Here.
Brown?
Present.
Shivers?
Here.
Guzman?
Here.
Krieger?
Here.
Mark?
Here.
Mercado?
Here.
Munoz? O'Reilly? Poindexter?
Here.
Robbie? And Starr. Thank you.
Thank you. So next on the agenda is the call for public comment. So State Bar staff will attempt to call members of the public in the order they appear on the attendee pool.
If there's anybody participating on Zoom right now who'd like to give a public comment, can you please use the raise hand function on your screen at this time? If you're participating by phone, you can raise your hand by pressing star and the number 9. Each speaker will have 2 minutes and there'll be an on-screen timer to let you know the time. Is there anybody who'd like to give public comment at this time? Please use the raise hand function. Okay, I don't see any raised hands.
Okay, great. Thank you, Angela. So I think we will move on to approval of the meeting minutes from the December 1, 2023 meeting. First off, are there any corrections or modifications anyone has? I'm sorry, Joel, I can't hear you.
I'll move. We adopt the minutes.
Any seconds? All right, great. I guess we'll take a vote.
Thank you. This is the vote to approve the minutes for December. Brown? Cal?
Abstain, I wasn't present.
Okay, Bradley?
Abstain, not present.
Shivers?
Yes.
Guzman?
Abstain, not present.
Mark?
Yes.
Mercado?
Yes.
Munoz? O'Reilly? Poindexter?
Yes.
Robbie? Starr? And Krieger?
Yes.
All right. So we have 5 in favor, 0 no's, 3 abstain.
So does that pass then? I'm not sure how many yes votes we need.
Yes, it carries.
Fantastic. See, we're being productive already. So I don't have a chair report this month. So we're gonna move on to the staff report, which is the next item on the agenda. So Erica is gonna share that with us.
Thank you, Brandon. I will be very brief. 2 things. One relates to the Bagley-Keene changes. Everyone should have received those in an email. And it looks like everyone is doing so. So we are an advisory body. So COPRAC is able to attend remotely, as you're seeing here. Staff is present. That's Angela in the San Francisco office in case any members of the public do decide to attend. Another thing to note related to that is that for 2024, the COPRAC is able to attend 2 in-person meetings. I did just want to note that we only have 1 scheduled right now, which is for October of 2024. So perhaps at the end of let's keep that in mind, and then perhaps before the meeting ends today, we can discuss what other meeting it makes sense to have as the second in-person meeting. We used to use one of those for the ethics symposium. I believe at our last meeting, there was general consensus that it makes more sense to continue to have the symposium as a virtual symposium to promote attendance. So it would be an in-person true COPRAC meeting as opposed to a symposium. I can answer questions on that. Otherwise, I can move on to the next quick item.
All right.
All right, I'm going to move on. The other item is just very quickly, at our last meeting, we did briefly discuss that COPRAC is subject to sub-entity review. in 2024. We are still finalizing details of what that will include. And by we, that means the state bar, not me in particular. But I did just want to give you an update on what the estimated timeline for that is. So as far as what will occur, we will start in phase 1 around the end of March. And that at that time, it will be scheduling calls with staff and perhaps committee members as well. The ultimate goal of this project is for the sub-entity review to end with a presentation to the Board of Trustees in July. So it'll be about a 3-month process, and then staff obviously will be drafting the information that will be provided to the board in July. And I can answer the questions that I know the answers to on that, to the extent anyone has questions, but it's still under development right now for the most part.
Okay, and so there's nothing for us to do at this time. It is just wait until the process is finalized and we can answer questions or provide materials as it comes up, right?
That's correct, yeah.
Yeah, just so you know, the SDTC is going through that, and I'm scheduled for a Zoom interview next week. So it's pretty simple. They'll just call you up and tell you they want to talk to you, and then you show up and answer their questions. So
Are you allowed to have counsel present, or?
in my case, I think they recommend it, but
Okay.
no.
Raquel,
All right.
do you have a question about this too?
I don't have a question. I just share with the committee. I sent an email to the chair and staff. I watched the December meeting, so I heard what was presented, and I have some concerns and some suggestions. I think sort of doing some kind of random sample of people and then making a decision on things, I just think it's a flawed, it has all kinds of biases before you get started. And so my intent is to say, here's at least for them to consider how they do it. They may not do it, they may not make any changes, but I think they're starting off with a process that's just flawed. And so, because it has survey bias just from the way it's constructed, and they're making significant decisions based on it. So it's not about what the particular people are going to say. It's not going to be representative. And I heard Joel share, the big decision that was made the last go around about collapsing the committee and putting, discipline in here as well. So I just feel, so as a committee member saying, hey, I just want you guys to know I'm going to say something, because what I heard raised grave concerns about what they're doing. And I realize they're doing it for expediency. But if you're serious about it, you probably don't want to just go fast and have it be flawed from the beginning, or just make the decision you want to make, right? And don't go through a process of sort of, we did it and we came out with what we wanted, which in some ways, given what I hear, is what it feels like. So I just want to share that with the committee. Over.
Raquel, excuse me, but what survey are you talking about?
I'm calling it a survey, but it's the sub-entity review.
Oh, okay.
Right. So I'm calling it a survey because basically that's what they're doing. They're surveying a certain population of current and past members.
So Raquel, if you're up for it, I think it might be really valuable for you to, make like a memo of some of your concerns and suggestions, and we can even talk about whether it would be productive or counterproductive for the committee as a whole to make this suggestion, or whether you want to just do them yourself. Because I think it sounds like a really useful critique of some of the decision making. I don't know how well received it is, or would be, but we can only control what we can control. So I would love, if you're up for it, I'd love to just sort of see a memo on that we can all discuss a bit.
Okay, thank you.
Thank you.
Nothing further. Over.
Brandon, just want to let you know we do have one public commenter who submitted something in writing who'd like to give a public comment right now.
Okay, that's just fine. Let's take that comment. Angela, are you able to?
Yes, let me just see. Okay, so Tina Colebrook would like to give a public comment. Tina, you will have 2 minutes to give your public comment. So please go ahead and begin whenever you're ready. Tina, are you there? Tina, are you there?
I can see Tina's Zoom sign in now, but I don't hear any audio.
Tina, if you're there, if you can make sure your volume is turned on, your speaker is turned on, you can begin giving your public comment when you're ready.
All right, it doesn't appear
Well,
to
can
be.
you?
Oh, there we
Can
go.
you hear me? Okay, I'm sorry. It's very difficult when you're trying to do this by phone. I wanted to make sure I was saying my comment at the right time because I had a comment and I put questions to the committee by email a few days ago. And my comment is about the fact that in regard to ethics of attorneys and the state bar rules of professional conduct. I'm wondering why, when all these rules 6106, 6108, and the oath of office state that attorneys are not allowed to lie or mislead any party or the courts. And then California has this litigation privilege, which actually does allow them to lie with intent and impunity. So where are the regulations and why does it conflict completely with your state bar guidelines on attorney deceit, all the rules? And I'd like to know why that is allowed.
Okay, thank you, Tina. Would you like to say anything else? You still have 47 seconds.
No, I'm just really puzzled as to what the situation is that you have made a rule or a law that allows litigation privilege, which in essence, insulates any attorney from being held accountable for deliberate, intentional lies, and when they admit to those lies and the intent to defraud in writing, and nothing happens to them. The judges say, oh no, we have litigation privilege in California and they're allowed to lie. And that goes against the oath of office. It goes against all your rules of professional conduct. And I want to know what we can do about that and how we can stop it.
Okay, thank you.
Tina,
Now you start time.
can I ask a clarifying question?
Oh.
I understand if you're talking about the litigation privilege in Civil Code Section 47, that is something that I understand would shield anybody who makes a statement in a court proceeding from civil liability. But are you suggesting that that has been used to prevent discipline against an attorney, which is separate from civil liability? That's where I'm confused.
Yeah, I'll jump in only to say that, so typically in the public comment process, the public commenter gives their comment and it's received. Tina, if you're still listening, staff will respond. I'll reach out. We do have your email and we will respond outside of this meeting.
Great. Any other public comments or is that it?
That should be it.
All right, thank you. So the next item on our agenda is G1, Ethics Symposium Planning. And, a lot of work goes into the symposium, so getting an early start is always very helpful. So I think I will turn this over to Erica if she wants to walk through the prior topics and just, generally talk about how we go about this process.
Sure, thank you, Brendan. So Attached to the materials, and Angela's going to put it on the screen in case you didn't have a chance to review it in advance because it was posted yesterday. We wanted to provide the group with the recent topics from the symposiums over the past 3 years, as well as who moderated those panels. In addition, we wanted to provide past topics that were considered or suggested by the committee, as well as members of the public who attended the symposium, as kind of an opportunity to start the brainstorm process. Ideally, if we could accomplish today, at least having a few topics in mind. We will need 4, as you can see. We typically do 4 programs. One is always the recent developments in legal ethics and professional conduct. So we really need 3 additional topics. I think what is most important to accomplish today is, to the extent we can get anyone to provide, if you are interested in being a moderator this year, please let us know. Typically, if there are more people that want to moderate, then we have opportunities for it. Typically goes in seniority of members of COPRAC, but if not, and you want to moderate, we can certainly work with you on that. And then the staff will be working with COPRAC leadership, as well as those who want to moderate, to finalize the panel topics and then start working on gathering speakers and such. And I'll just note that in addition to the topics that were offered, Angela did post the proposed timeline, the tentative schedules and deadlines. So we have, about the rest of the month essentially to identify the topics and then possible speakers. Then we'll start reaching out to those speakers and hopefully have the panels and the speakers finalized by about the end of February.
I would just suggest that we should have another AI panel. I think Ken Bacon did a great job last year. I think, we've done as a committee a huge amount of work since then, done our guidelines, and I think we should talk about that. And people seem still to be interested in it.
Yeah, I would agree with that. Is there and I haven't looked at all of the past topics, but can we do a UPL topic? Because we can't cover it in ethics opinions directly. And it's one of them, I get questions about UPL a lot, unauthorized practice of law, sorry. And it might, because we don't, as a matter of policy, issue much guidance on that topic, it might be something that would be a good, symposium presentation. And beyond that, I don't know exactly the focus of it, but it's something to explore, I think.
I think that's a great idea for allowed.
I would encourage UPL with multi-jurisdictional practice.
Yeah.
Have those 2 together, because that comes up quite a bit.
And that's something as a committee we're never really allowed to address. And I don't know if that would be unauthorized practice of ethics presentation, but I would like to know if we could do it. Raquel?
Oh, hi. I would like to volunteer to be a moderator. I think I have some topics, but one thing last year I think the committee asked for was to see the survey results, and we were going to get them closer to now. So if we have those, to be able to see what people's comments were about the less about the topic, but more about how it was done, because I think that would be helpful. So Mimi, what I understood Mimi to say was, I'm not going to give it to you now. I'll give it closer to when we're going to talk about it again. So if it was sent, I don't remember. So if we could just at some point have it resent. My frame should be sort of, we should select things overall that the bar and COPRAC want to either inform, make a guidance on, educate, communicate. So I think that's the frame. So certainly the bar has some things and COPRAC has some things. So that's my frame. So as much as we've been talking about in-house counsel and sort of some of the issues with that, I also see it was on the list of people say they were interested. That seems like a topic. Seems like succession planning is a real big thing. That is something we should be putting on people's mind about how to, think about it. I don't think anybody on the list, I didn't notice anybody saying it. I do think AI, there's something about the 8.3 that we should be reinforcing. I think last year, I don't know if it had just happened, and maybe it was just in the leadership sort of, what do you all call it? The first opening panel, forgot what it's called. Recent development. Yeah, I think it maybe was in there, but it was very low level. There's a lot of training, like you said, Erica, that's going on. So I don't know if it warrants being part of it, but it seems like it's a pretty big deal. So if you may be getting a different cross section of people, that may be worth it. So those are somebody, I didn't understand sort of what would be the implications of, somebody said they wanted how to work with people of different genders. So I know Bakita and I are doing an implicit bias, and we have had some conversation for Santa Clara Bar Funky Credit Day. And we had some conversation about sort of how that may play out in the court situation, and some of the biases that happen around that. So I don't know, that seems to be very topical. But I don't know, I realized I didn't know sort of from the topic, where would we go with that? Over.
Okay. Thank you. Joel, you have your hand raised?
Yeah, a couple of things. Looking at past topics suggested by attendees, the one that kind of catches my interest is from 2021, smaller firms and solos. There's a list of 5 different aspects of that practice. I think that, a lot of the ethical issues that arise come from small firms and who just aren't, or solos, who really aren't up to date on this kind of stuff. And I think that program, go down to 2021. Well, anyway, so I would suggest that for a topic. And secondly, regarding AI, it was interesting. Yesterday, I attended an all-day seminar online, sponsored by the Sandra Day O'Connor School of Law in Arizona, about international arbitrations. And you'd think it was going to be a yawner, but it wasn't. And what was amazing was the first hour was technological advances in arbitration. And they started out with the ghost of arbitration past, and they had an arbitrator sitting in the room as a real panelist. And then the ghost of arbitration present was a judge from Michigan who was participating by Zoom. And then they had the ghost of arbitration future, was an actual hologram of somebody participating from Amsterdam. And then the fourth one was super future, was an arbitration of this fellow, I can't remember, I think he's from Chicago, who has developed, it's almost like a video game. It's a virtual arbitrator, and it shows him sitting in a picture of him sitting like almost like a video game with his image sitting in a conference room. And he explained how with AI, pretty soon you'll go to an arbitration and the arbitrator will just simply shake your hand, introduce you to the conference room, where the program will be loaded up with the parties' briefs and the evidence and that kind of stuff. And the virtual arbitrator will make the decision. And he said that the interesting thing about it was that he said he recalled a Saturday Night Live skit about this monkey arbitrator, and how it was this part of the skit was the monkey is shown shining objects and fruit and bananas and things, and is always distracted and is prejudiced. But he pointed out, we're all monkeys, and we're all distracted by our biases, and will AI, as the virtual arbitrator, be able to make decisions without those prejudices? and he's working on this program, and he was able to demonstrate his work to date. But it was just a really interesting thought about AI and how it affects arbitrations and that kind of stuff. And, you know, that might be worth exploring as well. I also, notwithstanding my browsing success last year, I'd like to be a moderator. And if we do the small and solo firms, I'd be happy to take that on. If no one else wants the AI piece, I would do it, but I don't think I could do what Ken did a year ago. So anyway, that's my thinking on the topic.
Ken, sorry, Joel, I would ask that you flesh out some of the ethical issues that you would want to address in the solo firm, small firm presentation, because I think that sounds like a really fruitful area, and that'd be a really
well,
good
there's in
presentation.
the materials that we just got, or
Right.
it talks about the 2021. There's 5 topics, and that's a good start. And I suspect if I give it some more thought, we could add a couple of more topics and kind of give some guidance to small and solo firms about the unique challenges they handle ethically and as practice, you know, like case management tools, it says here, liens, how to promote business, billing practices, and how to handle difficult clients are the 5 things. And I think it'd be a pretty useful topic to what seems to be an underserved audience of observance of ethics. So, yeah, I'd be happy to do that.
Great.
Yeah, I mean, I agree, Joel. I mean, I don't, yeah, I mean, cause a lot of my risk management clients are small and solos. That's just the market that I serve on one aspect of my practice. And I would love to market, push this out to them, say, please attend this. This will be helpful. And I think that you'll get a lot of interest from, I think those are the type of lawyers that will attend the symposium. So, and this would be tailored directly for them. So I'm happy to help with that as well, if that's a topic that we select.
I'll just chime in very briefly. So I think this is a really good discussion. I think what could be helpful is to some extent tease out what should be in the recent developments section versus a standalone program, since arguably at least AI, succession planning, and 8.3 could all be to some extent in the recent development section. I also just wanted to briefly note that for the compliance period that this program will be a part of, which starting effective the compliance period for MCLE ending January 31st of 2025, there are 3 new types of subfield credits that attorneys are required to receive credit for. So the COPRAC could consider whether or not they want to address any of those subfield topics. Those include technology in the practice of law, so arguably AI would fit in that depending on the content. Civility in the legal profession. The civility rules are still pending before the California Supreme Court, but it's possible that they could be adopted before that meeting or not, but that's certainly a possibility. And then the other one is there's now 2 hours of required competence credit for attorneys, but one of those hours can be in attorney wellness issues. So that's also an additional option. Not saying that the committee needs to do any of those for the symposium, just wanted to flag that those are new credit hour requirements for attorneys that they may be interested in getting.
Well,
Do we have?
I got a question, Angela. I mean, Erica. Just now looking at the small firms, you'd be covering tech, you'd be covering civility, And to a certain extent, you'd be covering the competence part, not involving social competence, if you will, or attorney wellness. And how does that work? Where
Sure.
part of a thing, part of an overall program covers it?
Yeah, typically it's done in half credits for the most part. So if it's half a credit, half an hour credit in technology and the practice of law, or half an hour credit in, so 0.5 in a civility in the legal profession, typically it's not winnowed down more than that necessarily. I'll also note that, you know, to basically take back everything I just said to some extent, the symposium is usually a legal ethics symposium for the most part. So there is an opportunity sometimes for there to be, you know, legal ethics credit plus another credit. So maybe we're looking at half and half. But I'll just note that typically the symposium has been an only legal ethics program. That being said, technology in the practice of law and civility in the legal profession, as well as the elimination of bias and implicit bias credits, are all things that very much touch upon professional responsibility obligations.
So if we
Erica,
jump in,
I
I just have a
I'm
question.
sorry. Go
If
ahead,
we just,
Nikita.
sure, thank you. If we decide to, excuse me, as a committee, touch on the subject of implicit bias or gender bias, then I'd be interested in being a moderator for that one. Your turn, Raquel.
Yeah, having heard what Vikita said, I will leave on the implicit bias. I wasn't suggesting it, but having heard Vikita, we'll leave it on. Over.
So, and I'll just make a note about that. I think one of the most profound areas of implicit bias that's on the horizon now is the bias in these AI engines. And one of the real problems with giving a presentation on that is implicit bias can be hard to recognize and hard to talk about, but doable in humans. But when we were talking about these black box computations, you know, where even the engineers are saying, like, we don't quite understand what's happening in there, but we know there's biased results coming out occasionally, it becomes a profound social issue and a really hard thing to give a presentation about. But we should give some thought to whether we can come up with something useful to the world on that, because it's a really big deal. I mean, and we know it, like, there are simpler ways that we see it. We know that all this facial recognition software is really accurate with white males, and like increasingly less accurate the less you look like a white male. And so that's not really a legal ethics thing directly, but it is one of the few areas where a non-computer scientist can see the problem, right? And we should consider that, whether built into our AI presentation or in some other way, because it's a big deal. And you know, Joel is correct. There are certain companies agreeing to private arbitrations with higher and higher levels of automation, just for the speed and efficiency of it. And it's hard to even know what bias is cooked into those things. And so it's a potentially important topic for us to talk about.
Yeah, also, I just like to say that with, you know, DEI and being under attack elsewhere right now, I don't think I'm the most competent to participate in a program, but I really want to just throw some support to. We need to highlight that and fight the trend that seems to be trying to get away from consciousness of that particular bias, and talk about the ethics and importance of doing what we can to eliminate it.
It's very interesting. I mean, I don't know if we could get together a deep enough presentation in time, but there are just really profound issues. Like, we know that insurance companies set their reserves for claims based upon a ton of factors, right? Here was the injury. Here's what we think a jury would award. Are they building in assumptions of bias by a jury based upon the identity of the person that was injured. Like, I don't know enough. I mean, this would be a really huge undertaking. A lot of these things are more, areas of expertise that we already have that we present on. And I don't think any of us have this particular expertise, but it might be really interesting.
I'll share a couple of podcasts on the AI part and related with the law. And it's and, some people may be a little conspiratorial that like, oh, it's premeditated how the biases are sneaking in, but in some way when you hear it, it's logical. But it needs to be shifted, but it is logical. So I'll share that. The gender one, I'll just share because I think I'll share what I understood that was said by a judge. I don't remember her last name. And Vikita may chime in if I don't get it exactly correct. But what she said that there was some kind of it was a family law case. The parents were in front of the judge. The kid wanted to be referred to as a different gender. The mother was fine with that. The father was not. The judge went and said, well, the judge was going to go with the father. The judge who we were speaking to said, there's a lot of implications about that because it appears already now you're, I don't know the word she used, but she didn't use bias, but like by doing that as a judge, you seem to be taking the side of the father. And so then where does that go?
Right.
And so I never thought about that, but there are that was a live case. And it's like, oh, when I read this and not having heard, if I hadn't have met the judge who would share the story, I wouldn't have known sort of what that meant at all. But the more the judge talked about it, I realized, oh yeah. And so she said, so if I would have been the attorney that was representing, I would say something because that's a slippery slope now. That because you're now citing, and so now when we get to some of the particulars of the case, are you now set yourself up to already be on one side or the other, just based on this idea of maybe how you're feeling about gender, and that you are who you are. So I don't know what the question is, but it's certainly there's many more people now identifying themselves in many different ways, to include now they, which is a whole new level. So it seems like there are some practical implications in the practice of law around this whole area.
There was a big high profile case relatively recently, and I might misremember some of the facts, but NBA star Dwayne Wade, when he was getting divorced. No, it was a custody thing. He was already divorced, but his child, and I can't remember the birth gender of the child, was identifying as the other gender, and he was very accepting of it. And his ex sued for full custody, claiming that his support of that was, going to harm the child. And you think about when that hits a judge, what does it mean to even be neutral in that? Everybody's bringing their beliefs, and it's very fascinating. I'm interested in the topic. I would like to see how it can be presented in a useful and sensitive way. I wouldn't want to do it if we couldn't achieve that. Erica?
Just to
Your hand's
add
up?
to,
Yeah.
Oh, go ahead, Raquel. Or
No, I was just saying I saw your hand was up. So
just to add to this topic, there was a very recent, the case may actually still be pending on appeal, but in the state bar court, a discipline case where a attorney used a phrase that has some gender bias associated with it. They were referred by the Court of Appeal to the state bar for discipline for using that phrase against a judge in that case. And it was ultimately at the hearing level found to be non-disciplinable First Amendment issue. And so that could be another thing to kind of add to the mix if this presentation moves forward, if this topic moves forward, excuse me.
Sarah?
Yes, I was just going to say on that topic, I've attended some CLE programs on and also facilitated one for another organization I'm a member of on um, recognizing and interrupting microaggressions. And I know a wonderful speaker on that topic. And I really like the way that presentation is because it's a little more interactive too. So I would just, if we're considering this subject of implicit bias, that may be one angle to consider as a potential way to present it. And we could weave in a lot of the other issues we've been talking about.
That's really interesting. I will say that in my practice, I probably see that more than anything blatant and out, like overt. Just to share a story, a friend of mine was in a hearing, and my friend was the only woman among 4 or 5 counsel in a complex case, and they all referred to each other. The men referred to each other by name. Your Honor, I want to address Mr. So-and-so's argument, but they never used my friend's name. They just referred to her as she. And it didn't occur to her until about halfway through the hearing that like nobody's ever used my name. And it sort of seemed, I would almost guarantee none of these men realized they were doing it. And she got the transcript afterwards, and nobody had ever used her name when addressing her arguments, but they had for every other attorney. Very interesting issue. And then she tried to talk to some of these guys about it, and they were outraged that she would imply that they had ever done such a thing. So these things creep into a lot of spaces. I'd love to, I mean, it's great that you know a speaker on this too. I think that'd be really interesting.
Okay, while we were sitting here, I was just, my mind, I added 3 topics to the 5 already under the smaller firms and solos. So when I get that list all put together, where do I send it? Who's going to be collecting all this stuff?
Send it to Angela and I. Cool.
Okay.
Thank you.
So Erica, you want us to separately say what some of the recent developments panel, opening panel, you want us to identify some specific ones, or knowing that some of the ones we have on there may drop into there? What was your request? I lost your face. Oh, you're off camera. Okay.
Oh, I'm here.
So
there you are. Okay.
The way that usually works, it usually works that it's like, new developments in case law, ethics cases that have come out, we kind of squib and talk about. And then if like we didn't want to do a full AI thing or 8.3 thing, we'd kind of tuck it in there too. But it usually historically is like a survey of, recent case law or new rules or something like that.
Right. So as well as recent COPRAC opinions, to the extent there's any that have been published. So the guidance on AI would to some extent fit within that, because that's a COPRAC publication. Similarly, Rule 8.3 could fit in that. Civility could also fit in there if those rules are ultimately adopted, because it's kind of just what's new in ethics since the last symposium to some extent. Those are all also very robust topics, so they could be standalones as well. I'll just say, as it relates to Rule 8.3, all attorneys now have the ability to take a Rule 8.3 course from the State Bar as self-study credit for free. So it's already being addressed. That being said, I'm still getting asked to provide 8.3 presentations, and I'm sure many of the people on this meeting are as well still. So it may be something that's covered in other places where it could just be a relatively recent development.
I think succession planning should be in recent developments too. And I agree, 8.3, I think it should be covered, but I think it should be 3 minutes or just note that it has been passed and, go over the mechanics of the rule. But I think it's been well covered in the last 8 months or so, or however long it's been active.
Yeah. The thing with 8.3, I guess I would say whatever is a pinpoint that the bar wants to be making on that subject to people?
Yeah.
Right? Because you could be taking a course and you're taking away whatever you're taking away, but what do we want them to be focused on about that? And I think we should not be calling it the snitch rule, because that in itself is just a very negative connotation. And it's like we set ourselves up for the negativity by not co-prac, but the bar. Like, let's just call it the snitch rule. So I think not doing that would be much more helpful to what the intent of it is. And I forgot, is the recent development, was it, how many minutes is it typically? Seemed like it was not that long.
I believe
And
it's
I'm
an
asked,
hour.
it is an hour, okay. Because it seemed, it starts at the beginning, and let me just say, it doesn't start on a high. Like, it definitely, the symposium got better after that. So it seemed, so either some really interesting topics or not too many topics, because it just, like, it was a dozer. And I don't know if it was a topic, I don't know what it was, but it didn't catch people's attention. But I don't know what the survey said. People may say they loved it. Right. So it was just me, which I think is the benefit of having a survey, to kind of see what do people think of what did they think of it?
Before Zoom, when we would do these presentations, it was all legal ethics nerds that would come, and everybody get really into that stuff. And now it's open to the world, and people might not be as into the weeds, which is a really fair point and something we should be aware of, So,
and I didn't think it was into the weeds. Like I say, I just don't remember, but my feeling was, oh, it was just very, at the beginning, right? You make a big beginning and a big end, and in the middle, and it just wasn't something about it. I don't remember what, but it wasn't because it was technical. Over.
If the colleague impairment opinion gets voted out and approved, that could be a good one to cover in the recent developments, given there'd be a lot of interest, especially given the court order on Girardi that he's competent to stand trial, although he has a diagnosis and a medical opinion that he's not competent. It kind of highlights the difficulty lawyers are going to have in complying with the rule when they fear that a colleague might have competence issues.
Yeah. Any way that we can talk about that recent decision on Girardi, it would be fascinating for a lot of our audience.
No, it is. Did you read some of the evidence that the judge cited by confidence?
Yep.
The sweater.
The phone calls and the sweater. Yeah.
Yeah. It was just amazing.
If you're going to fake something, you got to be more thorough. It's a really interesting issue. Really, really interesting.
I also think, since recent topics is getting to cover a lot of topics, maybe we can move succession planning to small solo firms.
Yeah, that makes a lot of sense too.
What was that?
I know. Yeah, Joel, that's kind of in your, I thought to put succession planning under small solo firms topic. So it doesn't need to be a standalone topic. It could fall under recent developments, but maybe it is more appropriate under small solo firms. But I know you have got now 7 topics that you want to cover under, or 7 subtopics under that topic. So,
well, now I'm up to
8.
10.
10, okay.
But
so
I'm just going to give a list of everything that we've talked about, and then once we constitute a panel, we can kind of winnow it down and figure out how much time goes to each one of these things. Maybe 4 or 5 of them could just be a checklist kind of thing or whatever.
Yeah.
Smart.
Okay.
I'd be happy to be the moderator on the AI panel unless somebody else is really excited about it. We can figure all that out.
So I think you have it, frankly, based on these discussions. I think
good.
I'm hearing the recent development, implicit bias presentation that focuses perhaps on gender bias. the solo and small firm and AI. Did I list them all?
Are they an hour and 15 minutes? Are they an hour? How many do we do?
They're scheduled for an hour and 15 minutes. That's a relic of when we used to have the in-person and the Q&A. I think that still does make sense though. The questions can come in through the Q&A on Zoom as opposed to
Right.
in person. But
So
that's
we do
typically
four?
the presentation is an hour.
We do 4 presentations?
Correct.
Okay. Nikita?
So my recommendation, first, let me just preface this by saying I haven't attended the symposiums in the past, but I do know that typically when you have a panel on some of these challenging conversations like hidden bias or gender bias, it's more advantageous to have a panel versus just a speaker. So it would be my recommendation to have a panel instead of just one speaker regarding that.
Yeah, and I agree. I think that is our usual approach too.
Okay.
Not necessarily people with opposing points of view, although sometimes we can have that if the issue lends itself to it, but people with different perspectives, like,
Sure.
you know, from inside the trenches or advising someone or, you know, things like that.
And really on that particular topic to really kind of make it more interactive, to allow people to ask questions, because it's a very sensitive subject and kind of forcing people to get engaged.
So many years ago, I did this thing. I don't know. I hope it's still available on the web. It is a Harvard implicit bias interactive survey, right? Have you guys done that? And it's really fascinating. I mean, it's really fascinating. I don't know. I don't really think we have a mechanism to do something that interactive, but we can draw from it. I mean, it's important stuff. Yeah.
I did an implicit bias presentation. I can't remember if it was last year or the year before, but I used that test or survey or whatever, and I can pull some of my slides if whoever's moderating, if you want to take a look at them.
Great. All right, that's pretty good planning, right?
So just to recap, so we'll have recent developments. AI, Brandon, you are currently the moderator. Solo small firm, Joel, moderator, and then implicit bias, Vikita.
Well, I'll be working with Cassidy on solo.
Sure.
Did you just volunteer, Cassidy?
Can we do co-moderator? I mean, you know, like, but I'm happy to work behind the scenes as well. I don't necessarily need to moderate anything, but I'm happy to
be a panelist, Cassidy.
Yeah, isn't she? Don't you moderate?
Yeah, I'm happy to be a
recent
panelist.
trends?
Look,
I'm sorry.
I thought the co-chair and the chair typically moderate recent trends. Is that true?
Oh,
yeah.
I'm happy to do that too.
I'm very stealthily trying to wiggle away from that personally because I'm not good at it, and it's not. But you know, maybe I'll end up doing that too.
Okay, then I'll volunteer. I'm just a member, but I certainly would do that.
All right.
Because I'm not. Yeah, I'm not connected to anything, and I did volunteer, but we'll, you know. Cassidy, you're up for it. For Brandon wants to do AI, but not that. Is that what I heard, Brandon?
What you know, I'm happy if I'm happy to moderate recent developments. That's not really what I'm excited about, but I wouldn't mind being a panelist on small solo firms because you know, again, that's who I talk to all the time, and so I think I've got some pretty good insight on a lot of those issues that they face. You know.
Yeah, and this is in my experience, this is pretty preliminary and kind of shuffles around over the next couple months, which is fine too. But so it kind of changes. So Mary Grace, I see your hand is up.
I was just going to say that I have slides for the succession planning because I did a CLE with Aaron Joyce last year, specifically talking about not even just succession planning, but like slowing down your firm, because there's different ways to, you know, take on how you want to step out of the practice of law. Some people are looking to slow it down. Some people are thinking that they're going to hand it off. So I have a bunch of slides on like considerations, checklists, and that sort of stuff.
Great.
You can also sell your law practice. Here's my handy book on it's backwards. Selling your law practice. So that, I mean, those are the kind of questions I get too. Like, how do I, I want to buy out the partner who is retiring,
Right.
and that's a whole other, I mean, that's a lot of information, but that's something that people don't necessarily think about when they're either retiring or they have a partner who's retiring.
Mhm.
Great. Well, is this enough for one planning brainstorm? Are we good, Erica? What do you think?
Yeah, this is great. I think this is that we're farther along than we were last year, perhaps at this time. So that's fantastic. So I will shore this up with Brandon and Cassidy and Sarah as co-prax leadership. And then we can reach out to each of the volunteers or group volunteers separately to start looking into speakers. Thank you.
Sounds great. So next on the agenda is item B1, which is the colleague impairment opinion that we did a couple years ago before 8.3 existed. And there were many references in it to how we don't have a mandatory reporting rule, which are no longer accurate. So Erica did us the good deed of working on revisions that she will walk us through.
Thanks, Brandon. Yeah, so as we discussed at our last meeting, this was one that when we were kind of having our planning session about the opinions to prioritize for this year, this is one that as Brandon said, was approved effective in 2021. And it's one of the relatively few opinions that truly address the new rules. And so it seemed prudent to make sure that it wasn't indicating that there was not a rule in place when there now in fact is. So most of there's a few, nit changes just with a fresh set of eyes looking at it and to conform with other stylistic changes that the State Bar has. But the majority of the changes, as you'll see, relate to incorporating the fact that there is a Rule 8.3, as well as a bit of analysis in the scenarios regarding Rule 8.3. The opinion itself, none of the conduct that is described in the opinion as it relates to the impaired lawyer would be conduct that is required to be reported under Rule 8.3 necessarily. So I didn't delve too deeply into that analysis. We certainly could change the facts and make this a much longer opinion and address Rule 8.3. I'm not sure if that makes sense if the focus of the opinion is colleague impairment necessarily. The only thing that I will add is that there was also a footnote in here that described the lawyer assistance program. And the lawyer assistance program has gone through some programmatic changes over the past 18 months or so. And so the revised footnote reflects that, as well as there are two options, I believe in footnote 7, regarding changes to reflect what could happen with the succession planning opinion. So it's option 1 if the opinion is not adopted, and then option 2 is the new footnote that would indicate that there is a succession planning opinion in California, since these two, this opinion, if it moves forward, and the succession planning opinion will be on essentially the same path at this point. So we can walk through it in detail, obviously, if you'd like, or we can, if there's just anyone that has edits or comments, go through it in that manner.
I have a question, Erica.
Yeah.
And I have not read the opinion. So my question is related to the last thing you said regarding the succession planning. So is what you're saying, you're suggesting that these two go forward with something in them that is dependent on something else that happens? And so if that's the case, do you then go back and revise this opinion if the succession planning one does not move forward? And so I'm asking the question because my thought is, if that's yes, why don't we hold this until we know?
Sure.
So we don't not doing double work.
Sure. So two things here. The succession planning opinion, staff is still working with that working group to make those the changes that were directed at our December 1st meeting, which was voted out with staff working with the working group to make a few minor changes. and then I go out for public comment. We typically don't try and issue things for public comment during the holidays because no one's actually able to give us public comment, and it kind of subverts the process to some extent. So theoretically, this opinion and the succession planning opinion could go out for public comment at the same time. And then assuming that neither one goes out for an additional public comment, they could be approved by the committee at the exact same time and then presented to the board at the exact same time, meaning that they would be approved together. If that's the case, we would flag this obviously for the Board of Trustees when they approve it, and they would approve it with either option 1 if succession planning is not moving forward, or they would approve it with option 2, that footnote, if succession planning does move forward. So that's a process that could be involved. Alternatively, you're correct, Raquel, we could wait for the succession planning opinion to move forward through the entire process as an option as well. It just the attorney who's relying on this opinion to get 8.3 analysis, to the extent that that person exists, would not have that.
So so what you're saying, you focused on the trustees. I was thinking of the members. So for them, there's no implications of not knowing what is going to be the outcome of 1 or 2 in order to give what their comments are? Or would they now also, yeah. So I was focused on not trustees and whatever they're going to do, but public comment. Having something that is not firm. But I heard what I understand you to say, you don't see that as being a challenge for people to reconcile in their mind to give comment.
Yeah, we could certainly explain it in a very similar way to how I just explained it. This, at least in my mind, this footnote itself isn't really a substantive thing within this opinion. It's a minor cross-reference to this consideration as it relates to colleague impairment, just reminding the reader that based on the scenario that's provided, there should be a succession plan in place in this particular hypothetical if the succession planning opinion does in fact move forward.
Thank you.
So Erica, if and when everyone's good with this draft, what does our motion look like? Is it a motion to approve this pending approval of succession planning, or should we do it the other way? How do we do that?
Well, this would need to go, these are substantive changes to an existing opinion. So this gets to go through the public comment process.
Got it. Okay. Does anyone object to any of these revisions? I mean, they all seem perfectly logical to me, but maybe others saw issues.
Are we going to vote or decide on whether or not it goes out with the succession planning opinion, or are we voting on the sequencing of the rollout of this revised opinion? Because I would vote that. Yeah, go ahead. Sorry.
Oh, and you certainly could. So succession planning is not posted yet for public comment. It's going to be out for a 90-day public comment. So this could be posted with the succession planning opinion so that they have the same 90-day public comment period so that they're considered together. Based on how a lot of the committees that actually opine on or provide public comment on COPREC opinions, I do think it makes sense to some extent to try and batch these, or at least have there be some overlap so that committees can evaluate things it's just more efficient for them to be able to look at the pending COPREC opinions together. At least that's my perception. So it could be voted that this one goes out for public comment at the same time as the succession planning opinion. We would explain why there's options for this footnote that's going out for public comment. Or alternatively, we could hold off on this opinion, have succession planning go out for public comment, and then if there's necessary revisions to this to either revise option 2 or just stay with option 1, then that could happen thereafter.
So the quickest way to get this out then would be to hopefully have it go out at the same time as the succession planning one. I mean, I think the goal is to get this revised as soon as possible to eliminate the confusion over Rule 8.3's application. Yeah, so that would be my preference here.
Should we have a motion to with the succession planning? You know, once we have that vote, is that the best procedural way to go forward?
Yeah, so long as no one has any edits, yes.
Do you want to go through, Erica, really quickly what you did?
Sure, yeah.
The edits that you did make?
We certainly could do that. Angela, do you mind starting just from the beginning? Okay, so as far as the digest, the only changes obviously are just to alert the reader to that they may have obligations to report the impaired lawyer's conduct under Rule 8.3. I believe. Yeah, so right here, just a heads up. So because this opinion is an older opinion, we are asking staff to just confirm that these resources are still accurate and still exist where they are hyperlinked, but that's not a substantive change. Footnote 7, we just very briefly discussed. Those are just nits. You can keep going, Angela. Okay, keep going. Unless anyone had any questions on that, that's just to provide notice of the 8.3 obligations. So this is where the more substantive changes come into play. So there would be a deletion of footnote 17, which says that there's no version of Rule 8.3 in California, and then essentially replacing that on the next page with a very long sentence that describes the obligations at very high level under new Rule 8.3. And then scrolling down a bit more, I think this is where the committee may want to spend a little bit of time to the extent you do. All that is said here is that the subordinate attorney needs to evaluate whether or not they had a duty to report the impaired lawyer, and if so, report. And then it does a very brief analysis of there's failure to communicate issues here, and indicating that the lawyer would not be required to report. I do think the committee could consider whether or not there's a dishonesty issue that may warrant reporting. I believe in the hypo, I'm trying to get to that section. You know, I think this is a large question. Is it dishonesty to not communicate to your client your inability to you know, represent them effectively, or why you may have missed a deadline, or why you may have missed a hearing as occurs in these hypotheticals? That's certainly something that could be teased out a bit more, depending upon the committee's perception.
I'm just looking at this.
And I think that's kind of all of the changes, frankly.
So Erica, the last thing you said, question, which I think is, you know, would you have a duty to share with your client why you missed X, Y, and Z? Wouldn't you have that whether you were impaired or not? Like, is there some special reason? Or you saying you have to say, I missed it because I was impaired? Is that what you're suggesting?
Correct. So in the hypo, sorry, let me get to the hypo itself. The hypothetical describes the attorney bear with me for just one moment here. I'm scrolling back up to, it's on page 2. So if you're looking at, it's really like the middle paragraph at a recent hearing, that paragraph here.
Right, line 61.
Yes, thank you.
Yes.
If you're looking at that paragraph, that's basically describing the impaired lawyer's misconduct, right? So failure to communicate, a settlement offer, that's the largest thing here. And then if you look starting at line 81, you know, the denial essentially of having any problems. So on its face, it doesn't appear that there's any, we could certainly change the facts, but it doesn't appear that there's any direct evidence of true dishonesty. Arguably there's some like concealment here, but I don't think it necessarily rises to the level of something that would be required to be reported under 8.3 in the existing facts in this opinion. So there's two options. It could stay as is with that very, you know, relatively limited analysis, because the opinion talks about violations of 1.4 and 1.4.1, indicating that, you know, as well as competence. None of those are things that are required to be reported under Rule 8.3 as misconduct. We could alternatively change the facts of the colleague impairment hypo, where the impaired lawyer does something more egregious due to their impairment, and then have some a more robust 8.3 analysis in this opinion. This is a colleague impairment opinion. So I do think to some extent, maybe there should be an 8.3 opinion that goes into that more detailed analysis, and leave this as a colleague impairment opinion, and limit it to that.
That's my sense, because this opinion was inaccurate before your revisions, but I don't think the goal is to mission creep this opinion into becoming an 8.3 analysis. I think it's plenty to talk about how this is an issue. The 8.3 now exists, and you have an independent duty to evaluate your obligations under that, you know, in these circumstances. That's what I think is the better approach.
Yeah, I mean, I agree with that, but I kind of want to see public comment on this, because I think there's going to be lawyers that are going to grapple with, and you know, one of the main issues that they're going to grapple with is, do I have a duty to report? You know, and so you can't really ignore that, you know, as part of this opinion. I mean, you know, so I think there's a question of whether or not it is a fundamental part of this opinion, you know, or it should be. But you know, I agree, because I'm not, you know, I'm not sure that we need to change it into an 8.3 opinion, you know. But I'd like to see what public comment is about that, is going to be on that.
Right. I think that's really smart. And I do think, you know, you raise a good point. Maybe we need an 8.3 opinion. I just know that this opinion is pretty dense and pretty intense to begin with. To add a whole separate prong of analysis is a lot for one opinion, but it may be, I think public comment will be helpful for us.
Yeah. I mean, I like the change of the facts, is just like that there's an outright lie that is, you know, basically triggered by the, you know, impairment, and just you know, distinguish, because that on its face would be a reportable instance or incident, irrespective of whether or not, you know, it was caused by impairment, or, you know, a deliberate or something else, you know.
Yeah.
The cause isn't the issue, right? It's to point that out.
It
But
would be easy enough to change this to, you know, impaired lawyer appearing intoxicated at a hearing of some kind, and then the client asking, you know, being there with the attorney and the client asking them about it, and them saying no. I mean, it's not hard to change. That's a pretty straightforward hypo there. But it would change the it's still a colleague impairment opinion, but it's also an 8.3 opinion at that point.
Right, right. No, I'm inclined to vote against that, or, because then it puts the 8.3 on equal footing with colleague impairment. And that's not the intention of the opinion. Okay.
Do you want to do a straw poll of some kind on that issue, or does anyone feel differently?
I'm a little conflicted just because these conclusions are in the opinion that there was no duty to report. I know it's not an 8.3 opinion, but we're giving 8.3 guidance. And I don't know, if there was a really simple change that could not complicate it, like maybe the client asked, can't we settle? Have they made any demands? And the impaired lawyer said no. That might be a really simple way to trigger where there's an outright misrepresentation. I don't know. I'm not against going forward the way it is, because I think it's a great opinion and gives very meaningful guidance. And it could take a long time to get an 8.3 opinion out. So if there's something that we could throw in there easy that would trigger a duty to report, it just might be helpful in giving that distinction between where there is or isn't a duty.
We could table this until after lunch, and I could bring something back that maybe shows that, if that.
Okay.
I'm conflicted, but I'm at a disadvantage because I didn't read it. So let me just say that. So just from listening. But what Elizabeth said is my conflict. My disease. We've added 8.3, and we know 8.3 has its own opinion, and people, it's a mindset change. So people have to get used to even doing that. And so if you added something, but it's nothing in this opinion makes you have to trigger 8.3 other than say, well, you should look at 8.3. It seems like we're not helping ourselves. And so it seems like we should, and if it's just something like Elizabeth said, or something maybe Erica you have in your mind, that to me seems like it then makes the point of what 8.3 connection is to this more specifically, versus having people try to jump a leap to something that they're calling a snitch rule, which means they're not as inclined to do it. All right, so you probably being a little bit more explicit could be helpful.
So here's
and not adding 12 more pages, so it's not to try to make it more complicated, but to try to make a link of something that you said, well, based on what it was, now that we have this, we have to make a link. We have to join that rule with this opinion.
So I don't know if this will be popular, but one option is to have no analysis on 8.3 other than like the paragraph in the red line at line 551, just the first sentence of that, or even a footnote of that. Like, we're talking about colleague impairment. This is a colleague impairment opinion. 8.3 also exists. In every scenario you encounter as a lawyer, you better be thinking about 8.3 and whether or not it's triggered. We could offer no analysis here.
Can we? I'm sorry.
Well, I was just going to say, once we start to offer analysis, it should probably be more fulsome, right?
Right. That's what we're struggling with. I mean,
I don't know.
Can we just say that this opinion was originally issued before 8.3, but now 8.3 has been issued, so make sure you take that into account now? I mean, can we just be that straightforward about it?
I mean, that's certainly just an option that would just be a disclaimer at the top of the opinion. I don't believe that would require it going to the board or anyone. And I mean, that's a very simple way to handle it, frankly. I will say that if the analysis is changed so that the attorney does have a duty to report under Rule 8.3, it's not going to be 12 more pages to your point, Raquel, but it's going to be a few more pages probably, because they have to look at where to report, when to report the issues. You should probably bring in the analysis of at least the exception to the duty to report related to impairments, and indicate that it doesn't apply here based on how the information is obtained. So there's confidentiality issues as well, getting your client to be willing to allow for you to report the conduct, because this is occurring in a client based setting. So it's not so simple to, it really truly would be an 8.3 opinion, I think, is just what I'll say.
Yeah, I think that makes it a little too much.
But to Cassidy's, great point. There could just be a banner at the top of the opinion that says there is a version of 8.3. Ignore that footnote, basically.
I think this is more helpful. It's a quick way to get some 8.3 guidance out there without the time delay of working up a full opinion, and it's fits nicely with the competence issue. I don't know. I prefer to keep it the way it is and go through the process than just putting a banner. But
Yeah, I mean, yeah, because I was kind of thinking that too, actually, is that it's going to take a long time to get an 8.3 opinion out there. We know that. And so at least this will provide some kind of interim guidance specific to this topic for lawyers, just to say, okay, this is how 8.3 may apply in, this scenario, and kind of extrapolate that to other scenarios maybe, so that we do have some 8.3 guidance out there before we even tackle the full opinion on it. And so that's kind of an added benefit of going through the process without adding 12 pages. But I think you do need to add a little bit more analysis. So there's, than what we have here, if we're going to do that, I think.
Well, if Erica's up for it, maybe she can, use her lunch hour when we're all relaxing, and she can provide that language. Something for us to work off of and see what we think. I feel mean saying that, Erica, but you volunteered, so.
Well, yeah, like everyone else won't also be working on their lunchtime. I will, just to make sure I understand the ask, Cassie, so what you're saying is looking at line 551 in the red line version, Angel, if you don't mind scrolling down, just to provide a bit more analysis, saying that based on the scenarios, there was no indication that the lawyer, acted dishonestly. Is that kind of the line of thinking that you have here?
Well, I thought we were going to just add a blatant lie to the facts.
I think if we do that, we have to. I think if the opinion is changed in any way that would trigger the reporting obligation, I think it's more complicated than that. I think that you would have to address confidentiality, undue delay, the timing, all of those things. Yeah. So we could add to where it starts at 551 and just indicate, based on the scenario, there's no indication of dishonesty. Had there been, the analysis may change or something along those lines, but.
Okay, yeah, that's
good.
Yeah.
And Erica, I just have on that point, I think addressing to the, not just dishonesty, but the role refers to deceit as well.
Sure, yeah.
The failure to communicate situation would be helpful, that analysis.
Yeah, I think it's really, I think it's frankly a few sentences, if that, just indicating based on the scenario, there's no indication that there was dishonesty, deceit, or, reckless or intentional misrepresentation. However, had there been, the rule 8.3 reporting requirements may be implicated. It could be that sentence, frankly.
I just have one other quick comment to the edits that have been made already, which is on page 9 of the, I think, of the red liner. It's just kind of the generic sentence. I think when I was quickly reading this opinion this morning before the meeting, and initially I was just confused because I didn't understand. I thought this opinion had already been published, and then I realized that you were just updating it. But when I read this sentence, I kind of thought that maybe there would be a duty, an obligation under the hypothetical situations here, where I know that's not true when you read down below. So I don't know if there's a way to tweak this particular sentence. I know you're just saying generally you might have, but it depends on, whether the lawyer's conduct falls within the scope of that rule. And just maybe a simple, I think just this sentence could be misread potentially.
You should just be the other lawyer should evaluate rule 8.3, which requires an attorney to report certain misconduct by another attorney.
Yeah, I think that would be helpful, that edit, to avoid that potential misinterpretation.
I can bring that back. That's easy enough. I can bring that back after too.
Sounds good. That was my only comment. Thank you.
I see we have another rudder guide site here.
We do.
Oh, interesting.
Yeah.
And that's been in there for years, right, Erica?
Right.
At least, well, now it's 2024, at least 3.
Okay, so maybe there's no problem with that. Maybe we're not.
Maybe that's helpful for those of us still working on those minor succession planning edits.
Yes. Okay. Any other comments or thoughts regarding these revisions, and until Erica comes back with some other language for us to look at after lunch? All right. Erica, should we move on the agenda? I'm not sure when we should take it's too early for lunch, right? But there's definitely no way we should dive into ethics of in-house counsel right now. Should we look at, or what else do we have?
There's 2 others, both with Joel taking the lead.
Yeah, we could work on, I think it would make sense to talk about the standard of review and fee disputes, because I think that's a pretty discrete opinion, and I think it's in pretty strong condition. E1?
Yeah, that's what I was going to suggest, Brandon. That was presented, I think, about 3 meetings ago, and we had a lot of comments. I addressed all those comments, or I think in one case declined to add them in. And I think it's kind of ready to go. And I think that we could probably cover between now and lunch.
Yeah. So look, I think this one, Joel, I'll let you walk through it. My only thought was that there's sort of a takeaway from Pesh, or Peck, however we say that case name, which is that when you have a valid contract, it's a multi-step inquiry. The hourly rate will be set by the valid contract, but you still have to assess the reasonableness of the hours claimed. And that's the point of your draft here, but I'm wondering if we should say something like that way up at the front before discussion, just to tell people where this is going. You know what I mean?
Okay. Point me to the part in the back that you want me to move to the front.
Well, I don't know if we move it or just reiterate it. It is. So if we get to about line 92, I think the really the summary of what you're saying there, and I think it's totally accurate, is that the hourly rate will be determined by a valid contract, but there is still the arbitrator's job is to do analysis of the reasonableness of the number of hours or the tasks. You know, I want to distill it down to something simple like that to get people ready for the more fulsome analysis you're providing later on.
I think the key there is that I have to mention something in the summary about taking a look at reasonable billing judgment.
Right.
Okay.
Like the difference between not having the contract and having the contract is, yeah, you're going to get your hourly rate if you have a contract, but it doesn't mean that I'm prohibited as an arbitrator from examining the reasonableness of your hours. You can't claim 1 million hours for something you filed late, or, you know, all these other things that we do in any fee analysis. That second prong is still in play, but the hours that you think were reasonably incurred, yeah, this attorney will get the attorney's hourly rate in the valid contract.
Okay.
And just something in the summary to point us to what's coming, because otherwise I think this is like, I don't think I have any comments other than that, but and I welcome other people to join in because I jumped to the end. And
Okay, then I guess I would add a fourth paragraph to the summary, simply saying that even where there's a complying contract or complying agreement, it still is subject to scrutiny for reasonable billing judgment and similar activities.
Yeah, even, yeah, just like a sentence like that.
Okay, I can add that.
This will be really useful. I mean, this is one of those weird circularities where the PESH decision looked at the prior arbitration advisory for the logic of the prior arbitration advisory, and now we have to update the advisory to reflect the case law, which is great. It means that the arbitration advisory was really well reasoned in the first place. So,
well, what was interesting about the citation for the advisory in the PECS decision was that it said we didn't address what happens when there's a complying agreement. And
right.
In fact, that is true, but not in any formal way, but we covered that extensively in all the training materials every time we train. So
right.
I can, yeah.
All right.
You want me to suggest a sentence over the lunch hour?
Yeah, that might be great. Does anyone else have any comments about this arbitration advisory? I think it's really useful, like very, very helpful for people that are actually conducting these arbitrations, and really useful for people that are just struggling with the issue under many circumstances. You know, the majority of these sorts of disputes get negotiated resolution, and this is going to give guidance as to, you know, the risk factors in litigating the disputes. So.
Okay, I just found a typo and I'll correct that. And I'll put in the concepts you just mentioned, Brandon, and we'll see if we can't get something done after lunch.
Okay. Is there any?
Do these? Oh, sorry. Do these go out for public comment too? They do.
I have no idea. They never.
They
used
do.
to.
Yeah, I was actually
They
just
do?
about to. You read my mind, Cassidy. So. There used to be a different process for these when there was the mandatory fee arbitration committee. Since they are now under COPRAC, they follow the exact same process. So this would be voted out for public comment, and then they do go to the Board of Trustees for adoption in the exact same way that a COPRAC ethics opinion does. You'll also, it has the same, you know, disclaimer at the bottom as well, saying that this is a COPRAC opinion and advisory only, that type of thing.
Okay, but then will it live on the State Bar website with the other arbitration advisories?
Correct. Yeah. So
okay.
The arbitration advisories go still on the arbitration advisory page. What this would look like is it would have a new number and it would say supersedes advisory. Sorry, Ange, can you scroll up? What number is this? The old advisory number. It would say it supersedes 1998-02. And then 1998-02, which is listed on that page, would just be grayed out. There wouldn't be a clickable link to it.
All right, great.
Yeah, that's good. It gets more publicity, you know, because frankly, I didn't know these existed until well after they were created.
Yeah.
So it should, yeah, so it'll be good.
Okay, well, that didn't quite bring us to lunchtime. Now what do we do with even less time? So many challenges.
Okay.
Brandon, what's the subject of the ethics quarterly? Is that short? I heard.
I don't know. Great
Oh, okay.
question.
Well,
Let's ask
then,
Eric. Let's ask Erica.
yeah.
Maybe it's quick.
So those actually could be a good thing to talk about. There's two items that were agendized and there's nothing posted associated with them that we're just keeping as reminders on the calendar. So at the last, on the agenda, excuse me, at our last meeting, the committee had discussed having some sort of ethics quarterly publication to address hot topics in ethics that are maybe not worthy of an opinion in general, or where the law is not settled enough to have an opinion. So that's just a reminder, if there's anything that has come up that the committee thinks could warrant an ethics quarterly, we could certainly work with an individual, and staff could work with them on that as well. And then the other topic that we could briefly just talk over is if there's anything that the committee thinks needs to be done on the topic of AI at this time. So those are two that we could get through quickly, probably before the lunch.
Yeah, I thought on the ethics quarterly, I was gonna look at, because we do you know, a monthly tip of the month from my firm, and I was gonna look at some of the things that we did in the past or recently. Our last one was on the Corporate Transparency Act, so that's not really relevant. But that's kind of a one-off. But I can, Erica, if you want me to, I can pull some of our tips of the month and send them to you, and you can take a look at them, and maybe we can just start kind of brainstorming from there.
Yeah, I think that'd be great. I think that maybe for the March meeting, which is our next meeting, maybe we could do something similar to what was done for the ethics symposium this morning, is kind of go through some topics and see if there's anything worthy of being either a standalone topic or consolidated into just an ethics quarterly that could be, and then take volunteers for working on that document.
Okay. Hey. Talking to my cat, sorry.
And I welcome any thoughts about anything we should be doing currently on AI. I mean, we just did the guidance, and we're going to work up a presentation for the spring. But if there's any new pressing issue that someone has spotted, I welcome flagging it.
Well, you know, so one of the things on AI that's interesting, because everybody, I talk about it in various different, I'm trying to think, I was talking to, anyway, it's always a topic somewhere in some context. But recently I was talking to some clients about it, and, you know, my whole, you know, approach to it has been, is we should be very cautious. It's very scary, you know, using AI to write a brief should not be our normal practice. So, you know, young attorneys need to be trained on it, because and you know, senior partners need to understand that young attorneys may be using AI without, you know, much guidance or knowledge that they're doing it, all of that. But then there's the other side of this, and the Thomson Reuters state of the market report came out earlier this week. And part of their, you know, theme was that, you know, law firms are, if they're not going to get on board with advanced technology, they're going to go the way of Pan Am. Like, that was their analogy. Pan Am, the airline that went under because it didn't improve on its technology and, you know, get with the times kind of thing. And so, you know, there's this kind of drumbeat of, you better get on board with AI or else. So it's going to become the standard of care. or this,
Yeah.
the standard. And
Yeah.
I just, so I think that is a worthwhile topic to explore and to kind of maybe put the brakes on, or at least dig into that a little bit more before we get on board with that. I want to question that, as much as possible before we jump on that train,
So by the way, hand in hand with that, I had a presentation made to me last week from one of these, AI assistant legal, bespoke legal things.
Right.
And the only point I want to make is very clear to me that they read our AI guidelines, because their pitch was about how everything is satisfied. Everything we're worried about, they've already addressed. And they're really good at pitching this. And as a non-computer scientist, it is, it's a really weird position to be in. Oh, have you really solved? Oh, this engine won't learn from my data. Fascinating. I hope it's true. I don't know. But they are, just as a marketing, and maybe it's all true, and maybe they're just doing amazing work, but they are being really responsive to what we put out in the way they are pitching their products now.
I think we need to continue to be skeptical. Sorry, go ahead, Joel.
Cassidy.
No, Brandon, in this seminar I attended yesterday, when they were talking about AI, it was the sort of a prediction. They talked about, law firms' use of AI and disclosure to clients and that sort of thing. And the sort of overwhelming consensus that I heard was that pretty soon, provided that AI is appropriately supervised and checked, as any research tool would be, that in light of the cost savings to clients, they predicted that it's going to be a standard of care issue not to use AI. And they pointed out, and the first time I heard this, that recently they gave, I don't think it was the California bar exam, but they gave a bar exam to AI, and within 6 minutes it passed in the top 90 percentile.
Yeah. So I've heard that the statistics are shocking. I've also, in the demo I was presented with, it was like, here's a depot transcript. I want particular emphasis on these 3 items. Like, a few seconds later, you got it. Now, you still have to be a lawyer and apply some skill to what you're doing with that, but it'll be a standard of care issue before too long, and it'll be a reasonableness of billings issue. Like, oh, is it somehow, am I ripping off the client if I read the whole depot myself? It's very strange and incredibly disruptive. And we are right now at this precipice. And we saw it with Michael Cohen in his disciplinary proceeding in New York. Yeah. He handed his attorney, now he himself being an attorney, handed his attorney a brief to submit in his disciplinary proceeding. The attorney never looked at it or vetted it, I guess, submitted it, and it was all garbage, hallucination that Michael Cohen didn't know how ChatGPT worked. He didn't use a bespoke legal program, and he generated a whole body of law that didn't exist. Like, here's a principle that helps me, and here's 6 cases that make that the rule. They submitted it to the court. But, are we allowed to, we are not that far from somebody making the argument that if my client hands me some computer generated crap, I shouldn't be able to bill my client for me reading it all and vetting all the sources. The argument will be made. I think it's nonsense, but that argument's coming, right?
Yeah.
So we kind of saw that when people started installing Lexis and Westlaw, about, was there time sitting at the Westlaw terminal or whatever it was back in those days? Was that billable or not billable?
And we addressed that in our guidelines. The time you spent working with an AI is billable, subject to all the regular billable reasonableness rules. Anyhow, very interesting. Raquel?
A couple of things. One, Cassidy, I just looked up the Reuters report because I was interested in what you said, but it looks like you can't just get it. Like, they want to get your data, which I don't want to give my data. So if you have it, if you have the report, I'd be interested to read it. Oh, it looks like, okay, now the AI is working on Zoom. looks like you're done talking. We're gonna put your hand down.
Oh, yeah.
Okay. I noticed my hand was going down and I wasn't putting it down. So I was wondering, oh, maybe State Bar is doing that. So I guess to the specific question, I think in our guidance, or not our guidance, in our letter to the trustees, we identified some areas that we wanted to further explore. And I think those are the ones we should further explore. So I don't think we should wait until they become a hot topic. Like we said these are areas. I don't happen to remember specifically. I think there was one that was around the UPL, which we said, hey, we're not supposed to talk about that and whatever. So there was some things also about equity. So there was a number of things, equity and access. There was a number of items we said we want to further explore. So I think those definitely should be progressed, and then if there's any other ones that, as we're talking, people serve up. Hi, Bill.
Hello, everyone.
I think what this conversation is either a great topics for the symposium topic, or great topics for an ethics quarterly to go back to our two other agenda items for today. As far as Raquel, to your what is COPRAC recommending to what did COPRAC say that they would further study as it relates to AI? It was how to balance rules and guidance and the use of generative AI to protect clients and the public against its potential to facilitate efficiency and expanded access to justice. So balancing basically public protection against access to justice. Supervising non-human, non-lawyer assistance, something that we spent a lot of time talking about at our October meeting. And then something that was just discussed very much in this conversation, which is whether the duty of competency should specifically require competency in generative AI, and then the duty of communication as it relates to generative AI.
Yep, those were them. Seem all very relevant, and I don't think those are ones we need to see how the technology advances.
Yeah.
I mean, they're just things we thought were not of first order.
Yeah. It's very interesting though, because we're not detectives. So when they tell you that, okay, I've got all of your data is completely confidential, encrypted, and invisible to everyone except you, and the AI is not trained on it, that has huge implications to the level of disclosure to a client, right? But we don't know, like, do you have to take steps to vet the accuracy of what they're telling you, or can you rely? It's a tough issue, because they're all going to say it once that becomes the standard, right?
I think we're in for a rough ride.
I agree.
I mean, like, compare it to like Tesla. Tesla's great and the cars are great, I guess, but they also blow up a lot. I mean, like, there's a this is not a pitch for Tesla, but I'm just saying, like, that we put so much, we rely so much on these, tech people, and they're selling, they're marketing their technology, and we, as most lawyers don't know how it works, and I think we need to be super skeptical about applying it to our practice in such a holistic way. I mean,
right, because we specifically warn practitioners against over-reliance. But I'll tell you another thing they pitched. They said, we are using only a database, sort of like Thomson Reuters or whatever. We're using a closed database, so it's not scraping gibberish conspiracy theories off the web. This is real statutes and laws and cases. So we can't hallucinate. I don't know if that's true.
Right.
That's
what I'm saying.
lawyers.
Now
Yeah,
that's not true.
exactly.
Now that's not true, Brandon. They can
Yeah.
hallucinate. Yeah, yeah.
Right. So
Right.
it's
So,
very
so
fraught.
there's some kind of lawyer rule you should have stated to them, because that's a lie. So there must be a rule about that. Like, don't lie.
Well, no, how,
So you
historically, how many lawyers have gotten into trouble just because they picked up a head note and
Right.
never read the case? It's the same thing.
Yeah, yeah. I mean, you're right. You know, Joel, your point's well taken about the legal research analogy. You know, when Westlaw and Lexis came out. You know, and again, and Lexis now, I don't know Westlaw, but Lexis now has its AI component to it, and you can just plug in a question, an AI. You know, and I've used it a little bit. I don't. It's fine. I mean, it's not. You know, it's similar, very similar to regular research. You know, it's not not all that helpful, but yeah, I don't know. I mean, we'll see. Maybe I'm
I think
just
it's going to be
again.
like it's going to be like half of what COPRAC does in the coming years is deal with this issue. Or more.
I hope not.
Erica?
Well, that's a great segue. So COPRAC had the working group that was working on generative AI to basically meet the board's deadline back in October. That consisted of Raquel, Brandon, and Eleanor. And then I believe Hunter was a part of it as well. He's not here today. I think the question is that going to remain the working group that continues to explore these issues, or are other volunteers interested, or are people that are on the working group ready to be done in that role?
I'd like to stay on the working group or whatever new working group goes forward. Raquel, are you still interested?
Yes, I would like to as well.
And Eleanor?
Eleanor's gone. Oh, Eleanor's
Her
back.
phone is here.
Yeah, she's back.
She's having internet.
Yeah, I'm here. I've been having
Okay.
connectivity issues, so I dialed in, but I've been on the call the whole time.
Sure.
Oh, okay. I didn't see you.
Eleanor, would you like to remain on the working group for the AI project?
Absolutely.
Okay, great. So then the next question is, we had those non-member advisors who were useful, very helpful, very knowledgeable folks. Do we want to have such advisors going forward, and should it be the same people, or should we rotate that cast? I guess we should talk about that as a working group and just see what we think.
That sounds good.
Okay, great.
Is there any member that's on today that wasn't on that would be interested? I think we didn't ask that, right? Or is there some reason, Brandon, you're...
So Topeka's not here right now, and she might be interested, and Mary Grace could be interested. So, you know, maybe we should float an email after the meeting and solicit further interest.
Yeah, staff will do that. I believe, if I recall correctly, Topeka was interested if it continued forward. And then that is 4, and that probably should be the limit, so that we can keep Cassidy and Sarah updated in their roles as COPRAC leadership.
Great. All right. Shall we break for lunch? Anything more to talk about? We're not going to solve AI before lunch, so maybe we should.
I'm gonna have to join by phone after lunch.
Okay.
And I'll probably join, maybe I'll try to join as close to when we reconvene once I hear the time. Over.
Great. So should we reconvene at 1 o'clock California time? Perfect. Thank you.
Thank you.
All right, thanks. So we should, I would suggest we revisit the 2 agenda items we were just talking about, where we're going to examine some additional language that was going to be drafted. I saw that Joel, you've prepared some language. I don't know if we've had Erica, I don't know logistically if it's easier for you to start with the arbitration advisory or the diminished capacity.
Either one is fine, so long as, Angela, do you have Joel's comments now in the version?
I do. Do you want to do it first?
Yeah,
let's
do the arbitration advisory first, and then just because I think it's quick.
Angela, do you mind highlighting what was added additionally? Just for the, thank you.
I think this gets the point across that I was hoping to make. We can wordsmith it a little if we want, the two references to Pesh or Peck, but I think it gets the point across. Anyone have any thoughts on it? Well, it's just to be voted out for public comment. Should we, I mean, now's the time for comments. Otherwise, we should have a vote on whether we put this out for public comment.
Can we just have another minute or two?
Oh, of course.
Thanks.
Forgot I saw the language over the lunch break. Sorry, I'm not trying to rush anyone.
I think you need a including that there is. So for appropriate.
That there is.
And then you could get rid of the before exercise if those changes stay.
Should that be has been, that there has been, as opposed to there is, or?
Well, no, I think this is directing the arbitrator to engage
Okay.
in the scrutiny. But I
Okay.
understand that it's kind of a weird tense.
I wasn't sure if it, yeah, because you're talking about what is in this case, but okay, that makes, I'm fine with it if you think it's appropriate.
Well, could it be including that the arbitrator appropriately scrutinizes if it needs to?
Sure.
So if this relates to the arbitrator, I agree. That makes it actually more confusing to me. Or the sentence makes the sentence even more complicated.
So maybe we should even back up a little bit and say, assuming the arbitrator finds a valid contract, the arbitrator should still do the attorney's performance in accordance with the standards articulated in Peck, including appropriate scrutiny of the necessity, or something like that. I don't know.
The holding in Peck is that an arbitrator may enforce such contract? Is that what we're saying?
I think
Well,
that's
no, I mean, I guess what I was trying to say is that Peck says that if there's a valid contract, the hourly rate is the contract rate. But that's not the end of the inquiry. You still have to make sure that someone's not overbilling the hours, someone's appropriately doing tasks that need to be done. So the arbitrator still has a role scrutinizing the invoices, but then, whatever hours were reasonably incurred are at the hourly rate in the contract.
But if it's a valid contract, isn't that by nature not unconscionable? So wouldn't that language about it being not unconscionable be superfluous?
Well, you know what? You made a great point. The reason that language works is because Joel was using much more precise language of a compliant contract. Joel was calling it a compliant contract, which is what the arbitration advisory said before, which still then would require you to assess unconscionability.
All right.
But still, I guess my question is in this sentence, who is enforcing the contract? And that would be the arbitrator. I think.
And it's the exercise of reasonable billing judgment is that of the lawyer in the arbitration, not the arbitrator, or is that supposed to be the arbitrator too?
Right. I think that's where the confusion is.
Yeah.
Well, here's the problem. The arbitrator, whether the lawyer exercises reasonable billing judgment. And then will impose the arbitrator's own judgment. The attorney has not. Am I getting this right, Joe?
He's on
No,
mute.
let's go back and read this.
What if we did, I mean,
Let's
include,
go back and read the sentence. The holding in PET is that such a contract should be enforceable in accordance with the terms, provided that the attorney's performance is in accordance with the standards articulated in PET, including the necessity of the attorney's services and the exercise of reasonable billing judgment, and also provided that it is not unconscionable. So I would just, you could say including, leave it as is, including, but take out, including the, take out that there is appropriate scrutiny.
So it's just the necessity of the attorney's services and exercise of reasonable billing judgment.
but
Including the necessity of the attorney's services. And I would put in the exercise of reasonable billing judgment, because even if the services are necessary, you're still required to apply the exercise of reasonable billing judgment. So
wouldn't it make it clear though if it said, if you said including the necessity of the attorney's services and whether the attorney exercised reasonable billing judgment? Isn't that, seems like
I can live with that.
Yep.
be much more clear. Put that after the and right there.
Oh, sorry.
So it'd say, including the necessity of the attorney's services and whether the attorney exercised reasonable billing judgment.
I can live with that.
Exercised, I think, past tense. Yeah.
Yeah, there you go.
Yeah, that's exactly what they should do.
Are we good with this?
Okay.
Thoughts on this language?
Well, I'm satisfied. We should pull it out.
Do I have a motion to vote this out for public comment?
I motion to move it.
Second.
I heard that as Bill with a second by Cassidy.
Correct.
Okay,
And that would be for a 90-day public comment. Is that correct?
Mm-hmm.
So I'll go ahead and take the vote to, for this to go out for a 90-day public comment. Brown?
Yes.
Yes?
Yes.
Thank you, Cal. Bradley?
Yes.
Chivers?
Yes.
Guzman, Mark,
Yes.
Mercado,
Yes.
Munoz,
Yes.
O'Reilly, Poindexter, Robbie, Starr, and Krieger.
Yes.
So 7 yeses, the motion carries.
Great.
Cool.
So Erica, should we return to the impairment and take a look at the language there?
Yes. Angela will pull that up when she's ready.
Great.
So there are 2 sets of edits. The first starting on in line 300 or so. Let me. Keep going. There will be highlight. There should be highlight. It's line 332. Is there no highlight on your version?
No, Denise.
Okay, let me, I'll go ahead. Oh, and it's showing it was modified a while ago. I'll share my version, Angela.
Okay.
Sorry about that, everyone. Okay, so hopefully you can see it coming up on your screen. So I kept the original changed text in red line just so you had the comparison. The new text, however, is in the highlight.
Is it possible to zoom in a little?
Yes, of course. Thank you.
Thank you.
I did just to the extent anyone's wondering the thinking, I removed the where to report aspect of this because I don't want that. I think they need to look at the entire rule essentially. I didn't want to think that that was sufficient.
Erica, I'm confused a little bit by the, so you would keep in both of these sentences?
No, just the highlight.
Just the highlight. Okay, sorry.
Yes, no problem. I left the non-highlight just for sake of comparison.
Okay, gotcha. Sorry, I misunderstood. Okay.
Would you maybe perhaps, do we say anywhere what rule 8.3 is before this? Okay, yeah.
I believe it's beforehand. Let me just confirm that. No, we do not.
No. Yeah, so maybe just a prefatory statement somewhere to say that when it was adopted and generally what it is, or that it's called duty to report or something. I don't know what the title of it is. I assume it's duty to report.
I'm sorry, I'm doing so much scrolling. I'm trying to get to the language that does explain it.
Oh yeah, so that's what so that's after though, or before?
Correct. It's correct. It's after.
Maybe move that before.
An alternative option, because it talks about all of the responsibilities in more, this is just like the introduction. we could remove the under Rule 8.3 and just do this very similar to what was done here.
What do you mean? I'm sorry.
So here it says the other lawyers owe responsibilities to the affected client, the impaired lawyer, and the firm, and it doesn't provide the rule references to what those responsibilities are. So similarly, it could say additionally, the other lawyers should evaluate whether they have their own duty essentially to report. We could remove the 8.3 reference here, keeping the rule references solely when we actually work through the rules later in the document.
Well, but I think that's kind of confusing because if you don't understand it, that it's tied to 8.3, you think report to who and what, right? Like, I mean, duty to, we would have to say duty to report the impaired lawyer's conduct to the state bar or an appropriate tribunal, but then we're back to the same. Can you just put a footnote? Can't you just take the and take the language from what you had before and say, Rule 8.3 was enacted in August. Yeah. Yeah, that's what I would do.
We'll fix that, make it an accurate footnote number offline. Should I move on?
Effective on August 1st. I don't know. I see it both ways.
No, I'm sorry. I meant, should I move on in the document? Apologies.
Oh, yeah. Yeah, I'm fine with this, with that change, I think.
Okay, and then the other change was starting at line, so just to be clear, this would stay starting at line 551. The new text is what starts at line 553 in highlight. And then the text that previously existed in the document is still shown starting at line 572, but would be deleted. And there's much, I went through in the text above, there's several possible violations raised by impaired lawyer, including competence, diligence, failure to communicate, a personal conflict of interest under 1.7, and failure to withdraw as necessary under 1.16a and possibly b. And so there's a little bit more of that listed here in addition to explaining what must be reported under Rule 8.3.
So we don't think that the facts raise substantial questions as to the lawyer's fitness as a lawyer in other respects.
Well, I would say they do, but you only get to that step if they have also engaged in it's a criminal act that raises a question or dishonesty that raises a substantial question. Clearly, the attorney has competency issues. However,
Right.
that's not required to be reported under 8.3.
See, I'm still struggling with the 8.3 analysis. And we've gone over it so many times.
The one we're trying to avoid here, yes.
Yeah.
It is confusing. Don't you think we're gonna underline weaknesses of 8.3 by talking about how this is not a situation?
I mean, frankly, Brandon, that's what a lot of the MCLE presentations that I am a part of or that I've attended kind of touch on, is just, without even trying to, is just how limited California's version of 8.3 is as to what must be reported.
Yeah, we're good at saying what doesn't have to be reported. Does I guess I'm having trouble with significant misconduct, engaged in significant misconduct. I don't know. Did you reach that conclusion elsewhere in the opinion?
What if
We
you
could
just
just
said
delete that clause.
or you can just say although the impaired lawyer has violated several rules of professional conduct. I mean, I guess that's a nicer way of saying significant misconduct.
Well, I mean, in the previous sentence, impaired lawyer has engaged in several possible violations of his ethical duties. Yes, so I think you're saying it there. And then you're reaching the conclusion that those possible violations equate to significant misconduct. And I don't know if that you can reach that conclusion. I think you could, but I think it presents confusion in the context of 8.6. Or maybe it doesn't. I don't know.
Sarah?
Maybe I'm just being nitpicky.
I just saw Sarah's hand up.
Sorry, my comment was, I feel that this seems pretty lengthy and perhaps a little repetitive. When we're saying again, because now we've defined it up front, but we're saying again what Rule 8.3 requires. But I think it's much more helpful when you kind of explain it down below, that there's no credible evidence that the lawyer committed a criminal act or engaged in dishonesty, fraud, blah, blah, blah. And I think that's where we should just drop a cite to Rule 8.3 following that sentence, rather than, stating what it is up front and then repeating it again near the end to show why it doesn't. So I would just streamline.
Would you make what's highlighted a footnote, Sarah, just so to make sure I'm clear?
Yeah, I would just delete it there and then just add a cite to Rule 8.3 where you're explaining that there's no credible evidence that impaired lawyer committed a criminal act or engaged in dishonesty, starting at line 564 of that sentence. Which the end of it add a footnote with a reference to Rule 8.3. And I think it's fine if you do like a parenthetical kind of quoting what the rule says in the footnote there. Yeah, so maybe that's. And the other comment I had is following up on what Cassidy's comment was, and perhaps if we're deleting that, although impaired lawyer has engaged in significant misconduct, maybe a transition would be just however or something before, because we're saying they violated all of these rules, but nonetheless, there's not insufficient facts to show there's duty to report. So I just thought a however might be a good transition there.
Yeah.
Let's get out of.
Yeah, I think that's good.
Would you get rid of this, however, then, just because there's already?
Yeah, I think you can get rid of that, however.
This could so easily be an 8.3 opinion, because looking at the next paragraph, which describes how they can go to the ethics hotline or the lawyer assistance program for guidance. Those are both exceptions to the duty to report under 8.3.
Right. Yeah, I was kind of thinking that before too.
I just have one other comment, and it's just the way the footnote is reading, which was summarizing what the rules says, but the way it's worded to me, the criminal act under the rule, it's kind of clear that this criminal act, I believe, does not have to raise a substantial question. It's the dishonesty, fraud, or etc. Am I right, or is it criminal act that raises a substantial question too?
It's substantial question too. So like one DUI, you would not have to report.
Yeah, okay. So then I think that's correct how it's worded. Okay, I was just making sure.
10 DUIs, yes.
A lot of footnotes in this opinion. There's like 23.
Yeah, doesn't look like they're actually footnotes, so we'll have to fix that. But
Yeah. Oh, yeah.
Sorry, just as I look at this again, Erica, consider what you just said. I still think if you read footnote 2, that it looks like almost like it could be modifying just the conduct as opposed to the criminal act, the substantial question part. So I was looking at it again, and then looking at comparing it to how the rules worded.
would you want commission or conduct? Oh wait, wrong spot. Let's see.
Yeah, or maybe criminal act or conduct that raises instead of if the conduct, criminal act or conduct that raises.
Mhm.
Or I guess you need the if maybe, sorry.
Maybe if it.
Yeah, that works.
It's a mouthful.
Do we need the phrase subordinate lawyer under 8.3? Insufficient to insufficient facts to indicate that the the impaired lawyer engaged in conduct that must be reported by the subordinate lawyer. I would just, what if we just said it must be reported under Rule 8.3? So we don't ever lead anyone astray to think that there's some version of 8.3 that's different depending on where you are in relation to what your relationship is to the person that may or may not need to be reported.
For the same reason, would you want to just start with impaired lawyers violations in the next sentence? Or there's one sentence in between them, sorry, right after where it says footnote 2.
Yeah, that makes more sense.
Makes it shorter too, which is nice. Does anyone else have edits or need more time?
Erica, were there any other revisions in this that we haven't discussed?
No, that was it.
All right.
Those are the only revisions since the lunch break. And we discussed the others previously.
Okay. Any other, should we take some more time with this, or are we ready for a vote to get it out for public comment?
I just have one question on footnote 2. And it may be because there's been so many changes, I'm not following it, but would it make sense to say absent an exception? Rule 8.3 requires a lawyer, or do we think that's not necessary?
That seems really smart to me.
Absent, sorry. My computer's lagging. Is this, I mean, in general, I think, is this still needed with what is now a footnote?
Yeah, I was thinking you can even just refer back to the footnote, see footnote, whatever it was.
And then it would be here. And Sarah, maybe you want those same clarifying edits here. I think it's actually okay.
Yeah, no, I think this works.
Does anyone think just having it here is insufficient?
No, I think it strikes the right balance because this isn't an 8.3 opinion. So we just, have the footnote there once and reference it where, to the limited extent that you do here. But I think it's overkill to have it twice.
So we're deleting it from footnote 2 and just having it footnote 1. I'm confused.
Correct.
Okay.
It would just be at the top.
Well, I would put on footnote 2, see footnote 1, right? Where we had the full.
Could we just?
It's hard to.
I would think. Could we just cite to rule 8.3 here? I mean,
yeah.
Without explanation.
Or, yeah.
And I just, for footnote 1, would it be possible to add at this end of that sentence a reference to rule 8.3 A and D? I think when we're talking about exceptions, people might wonder what we mean. And I think we're intending to refer to subsection D as to the exceptions. But
would you put C and D? Because C is also an exception for criminal acts.
oh, yes. Yeah.
Anyone want me to scroll to anything else or?
Did we vote on it now?
There's a motion, yep.
Didn't we have one? No.
I'm-
I'll
I
move, I'll
move.
move.
I'll second.
Okay, that was Cassidy moving and Elizabeth seconding. Thank you.
Brown,
Yes.
Bradley,
Yes.
Chivers,
Yes.
Guzman, Mark,
Yes.
Mercado,
Yes.
Munoz, O'Reilly, Poindexter,
I'm gonna abstain.
Ravi, Starr, and Krieger.
Yes.
Bill, did you vote? I just didn't hear it.
Bill? I didn't hear it either, so I don't know that he can hear us right now.
Okay.
Do we want to wait for his vote or leave it as?
No, we
is?
can move forward.
Okay, so that carries 6 yeses.
Great. Thank you, Erica. Really appreciate it.
Yeah, thank you.
So left on the agenda, all we have left is the flat fees and termination, item D1. And Joel worked on that. So I'll let Joel take us through what he did on that.
We also have, I think, in-house counsel too.
Wait. Joel, I missed it completely. Cassidy did a ton of work on in-house counsel that I would like to bring by the committee. I'm sorry, I'm very distracted today.
No, it's okay.
Yeah.
I moved that Cassidy go forward.
Yes,
Thanks,
Cassidy's
Joel.
going to take the reins on this one. Thanks, Cassidy. And thanks, Joel.
Okay.
Sorry for that.
Okay, thanks, guys. So my goal here today, I think hopefully we can maybe, as I'm hedging, as I'm saying this, maybe vote this out. And the version we have here is a clean version of the red line that was most recently circulated. But then I redlined it a little bit more and have a few comments to guide the discussion. But before I do that, I wanted to pause and see if anybody had any of their own comments, thoughts, after they had reviewed the most recent version. So I think I edited it down, I think significantly, took out the last argument or last section. So I think it is shorter. So I'll just pause here to see if anybody had anything to contribute.
Cassidy, I did have some feedback after looking at the red line version that you circulated for this meeting.
Okay.
And I think, let me just see. Maybe it's only in the digest, maybe a site wouldn't be needed, but there's somewhere, and sorry, my notes are not great here, but we're talking about the compliance with the rule 1.8.1 when there's an indicia of inequality standard, it seems that we're applying here.
Yeah, line 31. That's I marked that to reword it because it was jumbled.
Yeah. So I think it's it might be helpful when we're talking about this, because this seems to be like a standard that's not entirely evident from looking at the rule on its face. So I think if we're talking about this type of standard, we should cite to, seems like we're relying heavily on the comments 5 and 6 and analogy to some of these other ethics opinions that have been issued, not in California, but I think it's in Washington or the other case. And so I just think a citation or kind of explaining how we reach this would be useful. And that goes along with just the other kind of more direct edit that I had is we talk about comments 5 and 6, but it's in a footnote. And
comment 5 and 6 to 1.8.1.
Yeah, I think it's in footnote. Let me just.
I think,
yeah, and I think 7, I think is the footnote. And I thought some of that is important enough to be, because we're focusing so much on these other states' opinions, but to incorporate it into the body when we're talking about why we think this is the, same rule would apply under California law. I feel like there's not enough analysis of that. So moving some of what's in footnote 7, where we're saying the comments to CRPC 1.8.1 are substantially similar and we cite to it. But I think a little bit more of an analysis here to show why we feel this same standard would apply in California, given the comments to our rule and the similarity. And so that was kind of.
Yeah, and you're right. And that's what I kind of picked up on too in my red line to the version that you guys looked at. But I didn't incorporate it into the digest. So I think, so the background on that is, I think the strongest support for the conclusion that we reach here is the comment 6. This rule does not apply to standard commercial transactions for products or services, and can't see the rest of it. No, keep your no, keep go. Don't scroll. It's just that my windows are in front of it. That a lawyer acquire from a client on the same terms that the client generally markets them to others, where the lawyer has no advantage in dealing with the client. The Chisholm case relied on that language in the Washington comment, which is the same. And so I think that gives us support for the same conclusion. And so I think it would be appropriate to cite to comment comment 6 and I guess comment 5. But comment 6 is the more direct cite. In other words, it's not like, the employment agreement is akin to these types of standard commercial transactions, although not exactly. but it's, you know, analogous enough, I think, that we can reach that conclusion. So do you want to, let's see, so should we then cite to comment 6, rule 1.8.1, comment 6 in the digest? After, however, in the in-house context, go ahead. Let's see.
What line, Cassidy, do you want to go to?
Line 29. No, so sorry. Yeah, that's right. Sorry. And so I think that sentence, however, in this sentence is the one I kind of wanted to reword. However, the in-house context, it should be in the in-house context. Respect to, or in the in-house context where the new lawyer is offered the same general compensation terms as those offered to other employees, and an indicia of inequality do not exist. Indicia, that's plural, right? Do not exist or does not exist. Compliance with CRPC 1.8.1 would not be required. And then we would put a cite to 1.8.1 comment 6.
I think that's helpful, Cassidy, and so we're going to delete the N before indicia since it's plural, right? Indicia, okay.
Okay, yeah. And then strike, it's duplicative, the sentence compliance. If you go to the next line, line 33. Yeah. Okay. Yeah, and then we can talk about that a little bit more when we get down to it. Okay, so the next, did you have more, Sarah?
I did. My other comments were, I guess, a little more minor, but it starts with the screening discussion. And I don't know if you can scroll down to this section that talks about screening. I'm sorry, I was doing this quickly and didn't jot down a line number. But from a high, let's see.
Maybe, yeah, keep,
I'm gonna look
if I can,
copy real quick too.
I can get to it quicker. Screening would be, never mind. 352, so you're getting there. 358, sorry. Something even different there. Okay.
Yeah, okay. I just thought maybe it would be here. Maybe just stating at the end of 367, that is may have acquired confidential information concerning technology through the handling of labor and employment matters at old company that is material to the
Let's see, or you can say material information, confidential, acquired material,
Yeah,
confidential
right.
information.
Yeah, that's easier. Yeah.
So go, yeah. Material, comma.
And the other comment I had to this section was just, I think it's around lines 381. At least on the version I was looking at, but now it's not. Okay, yeah. Although lawyer may have acquired confidential information.
Oh, we should put material.
Oh yeah, on 380, you mean?
Yeah.
Okay, yeah. Sorry, my I think that's all I have for now, Cassie. Sorry, I thought I had another comment on this section, but I'm not quickly finding it. So if you want to give your overview, and I'll come back if I identify there was one other issue I thought I had with this section.
Okay, yeah, no, that's fine, because we'll go through it. Okay, so scroll back up to the beginning. So yeah, so go down to my first comment. That's already been taken care of. The highlighted part. Yeah, so that's there. Keep going down. So you can take my CC reword, that's been taken care of. And then Brandon's comment there, that I think we took care of that too. Because my most recent change. Okay. Now scroll down to, hold on. I guess my next, okay, so the red line here, I took out, let's see, what did I take out? Oh, the version that I circulated had more facts about what happens after the lawyer is employed and the company is being sold. I think we should limit the discussion to just when we get down to the 1.7 discussion, and limit it to just whether or not an advanced conflict waiver is appropriate just based on the terms of the stock option agreement itself, and that there was, accelerated vesting, for example, if the company was acquired, and that, that may require that could be appropriate for an advanced conflict waiver. And that's kind of what we discussed there, but I don't think we need to go into a full discussion about a 1.7 conflict waiver during the course of the employment, if there is an actual acquisition and what to do then, because then that gets into advising the shareholders and the company and what we already agreed to eliminate at the last couple of meetings. So that's why I took out those facts. So I'm just limiting it to, identifying conflicts when you're about to take the job and you have your employment agreement in front of you. Does that make sense? Okay. Okay, so then the next comment, let's see, let's go down. Okay, so this sentence, this is under 1.9a, where we're talking about if the lawyer personally represented old company in connection with patent and technology matters, the lawyer is a labor and employment lawyer. So personal representation on those particular matters don't exist under or doesn't exist under our fact pattern. But I think I say here, therefore, would not prohibit. Okay, so footnote 4, go down to footnote 4. That's what this applies to. So 1.9a may prohibit lawyer from representing company on labor and employment matters to the extent those matters are the same or substantially related to the matters lawyer handled while employed at old company, and the interests of old company and company are materially adverse with respect to those matters. So basically, if lawyer personally represented old company on labor and employment matters that are related to, substantially related to matters that they may handle at new company and that are adverse, then 1.9a will apply. And so my question is, should we put an example in here to, explain that further? But now I'm thinking it's probably too much. Does anybody have any comment about that? Okay, let's just move on. Let's just delete that then. To the, yeah. Okay. Oh, go back up. I changed. So another thing that I did, that the headings, the organization of the headings were wrong. I felt, because 1.a and 1.b, or A and B, is either you personally represented the client, or you had or you were part of a law firm or legal department, and you had access to or obtained confidential information about a substantially related and adverse matter. But substantially related and material adversity applies to both 1.9a and 1.9b, and the organization of the headings didn't really reflect that. So I just changed the headings so that it was clear that substantially related and material adversity applied to both of those prongs. And then, so 1.9b, okay. But I think the headings still need to be, I misnumbered them, so they just need to be numbered properly. So I took out, so by changing the headings, possession of confidential information was kind of its own heading, so I took it out as a subheading and just italicized it, because that's just the only element under 1.9b. I don't know if anybody, does anybody think that's confusing? Okay. Then let's go down to the comment where I say, is this necessary? I think I'd like to take out the quote from the Dieter case where it says whether confidential material information would normally be imparted to the attorney depends on 3 factors: the factual similarities between the current and former representations, the similarities between the legal questions posed, and the nature and extent of the attorney's involvement with the former representation. Frankly, this has always confused me, but I feel like this goes into substantially related, not whether or not confidential material information was accessible by the lawyer while at the former legal department. I mean, I know that's the way that it's presented in the case, but I just find it confusing. Does anybody else?
Yeah, I can add, we teach this as a substantial relationship test factors when we do this normally. So yes, I think
okay, good. Because I'm like, am I crazy? Like, because they all kind of blend into one. And it just...
But that's how we're going through the new attorney training course that OPC currently is updating, and this is the exact practice we use to teach substantial relationship test that would implicate 1.9, obviously.
Okay, well then, yeah. So let's take that out. It's too confusing. So take it out all the way to the end of citing to 1455, 230 on line 231. Yeah. And then, yeah, and then in the in-house context. And then you can take out my, is this necessary site? Okay. And then, so a lot of of course, the cases that cite, these principles are disqualification cases. I don't know, I just felt like we were talking too much about disqualification as opposed, and that's not really the purpose of the ethics opinion. But I don't know, does it matter? If we're drawing conclusions about whether or not a conflict would disqualify a lawyer versus whether or not it's an ethical violation. Or does it make any difference? So I have, however, knowledge of a company's general business practices or philosophies alone is not enough to disqualify a lawyer under 1.9b. Maybe instead of saying that, we say is not enough to create a conflict under CRCP 1.9b. So take out disqualify under 245. Instead of disqualify.
Though, right? I'm sorry to.
No, it's okay. Okay, thank you.
Because disqualification is a determination by a court that a conflict rises to such a level that, because the courts have like this absolute mastery of their proceedings. I think there's plenty of times a conflict exists, which may well be an ethical violation, but the court will balance all sorts of interests and not disqualify. It's not exactly the same test, right? I might be wrong, but that's
what I'm saying.
Yeah,
right. So
right.
we want to say our test, we want it to, we want to say whether or not it's an ethical violation. Now, whether or not a court ultimately decides to disqualify a lawyer is a different question, or a somewhat different question, a related question, but not the exact same question.
Should we start instead of the word, however, we could say courts have held that, and then so we're referencing the courts, and then from that we can draw a principle of some sort that we.
That's a good point, because we are relying on court decisions who have, and that's, if we're citing that, we should be precise. Yeah, I would put that. So courts have decided, it's to keep however, sorry. And then put courts have found that, and then keep disqualify. Yeah, I think that's good.
Cassidy, do you want to go further here though, and perhaps apply the rule, reasoning, which is similar to the court's reasoning really, but that, general knowledge of a company's business practices wouldn't be sufficient under Rule 1.9b unless that information is material to the matter. It's kind of the same analysis would fall under our Rule 1.9b, that, the playbook wouldn't be enough alone unless it's material.
So we would say, so we just connect to, in that same vein, it's not enough to create a conflict under Rule 1.9b.
I think you would add a sentence maybe to the end of that citation string, something along the lines of like, similarly under Rule 1.19, a company's knowledge of a company's playbook, unless what's the material, would not be a violation or whatever under 1.9b.
Where do we have unless it's material? It's in here somewhere. Oh, is of critical importance to the matter at hand. Okay.
Right, but the critical versus material, the 1.9 language is material to the matter.
Okay.
I can't
Yeah,
recall when I read this before, but I wonder if it's worth just having a footnote that explains that 1.9 is discipline and disqualification is case law, but that there's a lot of blurring of the lines here, and the case law may be the case law interpreting this may be the basis for discipline, and discipline on this may be the basis for disqualification to some extent too.
Yeah. Okay, can we put like a marker there to word that, or do you want to word that? Because I agree, I think we need to just clarify.
Because that may be helpful as to why there's so many civil cases cited in the opinion in this issue.
There's got to be a prior opinion on conflicts that says this.
I think
So we can
is.
probably just draw from. Yeah. I mean, because I know that yeah. So maybe we can just say see or use the same language and cite to that opinion, just as a general matter. Okay, so we can work on that. So go ahead and delete my comment there as well. Okay, stop here. What did I say? Oh, yeah, I didn't like what I did here. Hold on. Let me see my version. Okay, so this is where we're talking about same or substantially related. And we reach the conclusion. Hold on. Okay, the inquiry involves current specific facts on two matters. Okay, well, yeah, I mean, we're illustrating that the lawyer's role as a labor employment attorney would be unrelated to their role as general counsel. Based on the facts there's no substantial relationship between the two roles. But then I have, and that's for the conclusion where it says here, based on the facts presented, lawyer's role in the labor employment department at old company is similar to their anticipated role as general counsel for company only to the extent that both companies are economic competitors in the same technology space, and not because of any actual work performed or knowledge gained while working for old company. This similarity alone is insufficient to render the representations the same or substantially similar enough to trigger a conflict under 1.9a or b. In contrast, had lawyer defended old company in a lawsuit by a former employee who asserted a claim to intellectual property, which the employee developed while employed by old company, lawyer may have come into possession of confidential information relating specifically to old company's patents and technology. If company has, and then if he goes to new company and as general counsel, if company has or develops similar technology that rises to the level of a competing patent or infringement claim against or by old company, a conflict of interest could exist or arise. So I was just trying to make the leap that there could be a situation where, lawyer as a labor employment attorney could have come into, possession of confidential information about technology. If then there's a subsequent patent infringement claim or competing patents, that, competing filing patents, that sort of thing, then there could be a conflict. But I think, I don't know, maybe we can just take that out because we're just assuming facts that aren't there. But I just wanted to illustrate that it's sort of like an ongoing analysis, and matters come up as, you continue working, it's not like, you know what your matters are going to be when you're employed, which is unlike when you are engaged, what the matter is going to be that you're going to be working on. So I think that's sort of inartfully explained here, but that's what I wanted to convey. So I will pause there to see if anybody has any thoughts on that, or if I should just take that out because it's just too cumbersome. We can just take out in contrast altogether and put in, and just start with, in this instance, prior to accepting employment with old company's economic competitor.
Certainly simpler.
Yeah, I mean, maybe it was just a sentence that's at the end. Let's see. What did I say here? Lawyer would be required to perform under Ferris by. And maybe at the end there, it should be, this is an ongoing obligation as the lawyer, as a, and, continues the employment with company. Something that says that it's an ongoing obligation there. So it's not just, prior to accepting employment, but, at all times you should be addressing whether any new matter or issue that as general counsel lawyer is required to address must be evaluated to determine whether or not there is a conflict with their former client old company. Does that make sense? Okay, so maybe put, let's see. Lawyer.
Looking at it too long, but I read it as like heavily implied already, so I'm not seeing the need for it, I guess, but I've probably been looking at it a little too long.
Okay, well, that's fine too. I mean, if you read it and say that it's implied, then I'm happy not to add more words to this opinion. And frankly, I'm at a loss for words anyway. So, okay, let's just leave it. Let's take out that. It's good that we take out that sentence within contrast. Okay. Let's take out these two comments. I think Brandon and I talked about them and reached a conclusion there. Okay. Material diversity. Okay, so I think this whole next section is, I didn't have much more. There's the screening section that we discussed with Sarah. Sarah, if you have any additional comments on screening, then now's the time.
Sure, I did. And it's just, we don't really, do we want to, maybe it's already too long, like you're saying, but do we want to get into when the timing of the screen and when screening would be appropriate? And we're on the.
Yeah, let me see.
A lot of the stuff that you were raising like to the extent that a conflict arises in the future, you know, up front, shouldn't the lawyer, based on the technologies that the lawyer might, for which the lawyer acquired confidential information, you know, at the outset, shouldn't any screening be implemented in the event of a future conflict?
Well, I mean, so you're talking about like this, what is it, the second or third sentence, given that old company and company are competitors with similar technology and patents, a conflict of interest may arise in the future. For example, company may elect to pursue a patent that directly challenges a patent held by old company for technology developed by its employees. Well, so, and then take out as discussed above there, because we took out that part that was discussed above. Under screening. But so I don't think screening is, are you saying that there should be a screen immediately? I just think it would only arise if there is if there is a actual patent infringement claim that's described there, and there was confidential information that lawyer was privy to. Are you saying that there should be a screen? There shouldn't be a screen immediately, just because they're economic competitors.
Yeah, no, I agree with that assessment. I'm just looking.
Angela, can you go down to the screening section? Just scroll down. And then take out as discussed above. And maybe put, hold on. Instead of may have acquired, put if lawyer acquired. No. The if, yeah, I should go, yeah. And lawyer should be capitalized. And then take out the lawyer before that. And then capitalize if.
So I have a little.
Oh, wait, no, sorry. That doesn't make sense. Sorry, go ahead, Brendan. We'll fix that in a minute.
Well, I just have a concern that I think this legal department is super small and maybe inappropriate for screening. And we could dodge that issue if we just went to the front end and made the legal department bigger. I don't know, because it wasn't like 3 lawyers or something.
Right, we talked about this last time.
Yeah, I don't think you can. Certainly, any screen in a 3-lawyer department is vulnerable to attack, right? As being not workable. I don't. Just a thought. Concern me.
Yeah, I know. I'm
Although
thinking.
I also, I mean, this adds some nuances, but I do know that there are some recent authorities that kind of talk about that too, in terms of, you know, you can make the measures, the screening measures stricter in smaller firms, and in today's like remote work environment, physical isolation is likely possible, you know, even in a very small firm or small in-house legal department, where the person who's being screened maybe is working remotely from their home office, or there might be situations where it could be an entire virtual, you know, environment.
Right.
So I don't think screening is like necessarily off the table in every, you know, just because of the size. And the California Lawyers Association has a great ethics opinion that addresses screening measures and addresses kind of in the smaller law firm environment steps to take. So I don't think that
good points. Good points. Yeah.
Never workable.
Okay.
It's harder. I agree,
Yeah.
it's harder.
So the question is, do we want to go into all that? I think it's worth citing, definitely, or highlighting, you know. I mean, we could dodge it all together and make the legal department bigger, you know, but I also think it's helpful to cite to like the CLA opinion. I recall, I haven't looked at that in a while. But I recall it. And then I did cite the two opinions that you sent me. One of them had to do with screening, Sarah. And I can't remember if it if it had anything to do with the size of the legal department, that the Take-Two Tech case.
Yeah, I'm sorry, I'm
But
not recalling immediately. I just thought there was one, and it might not have been in California. I just remember seeing in some kind of alerts I was looking at that talked about, in particular, the remote environment where, and screening being a little bit easier in the smaller,
yeah.
for smaller legal departments.
Okay, well, let's hold on, let me look here. What do we say here? Am I incorrect? Well, okay, so at the end we say, given lawyer's position as general counsel overseeing a legal department of just 3 lawyers, the company may also need to refer the matter to outside counsel for handling. Instead of we say also, we should maybe say
down, because I'm just not seeing the part that Cassie is reading.
Oh, sorry. So although it's 381, so although lawyer may have acquired material confidential information, it is unlikely that lawyer substantially participated in matters involving old companies' patents and technology because lawyers' work was limited to labor and employment. Therefore, screening may be appropriate, assuming it is timely implemented with the requisite notice to old company. Given lawyer's position as general counsel overseeing a legal department of just 3 lawyers, company may also need to refer the matter to outside counsel for handling. Maybe we put company may instead need to refer the matter to outside counsel for handling. Although that's still part of the screening. Well, are we saying that referring it out? In other words, see, every time I look at this, I'm like, there are new issues. We have to stop doing this. I mean, if screening's not appropriate, given the size of the legal department, or if it's just that lawyer was substantially involved in the matter, it's not that lawyer has to be fired, it's that lawyer can't work on the matter, right? So and that's what the case, and that's like that the case cited in footnote 5. Although, yeah, so the legal department, well, that's a good, yeah, so the legal department would be disqualified from handling any matter, but an outside lawyer could handle it. But yeah, assuming, but I think that is a screening measure issue, I think. So if it's, yeah. So, I mean, what I was thinking is if you didn't screen properly, and you had outside counsel and, outside counsel was, communicating with conflicted lawyer, then outside counsel gets disqualified too. And then you have to get a different outside counsel, right? It's kind of my, outside counsel can also be disqualified if they aren't, if the screen isn't implemented properly. So it's all part of, you still have to properly screen the lawyer and and the legal department, and outside counsel would have to communicate with nobody in the legal department. So I don't know if we have to go into all of that here. Because again, we're kind of just, the facts there's no conflict under our facts at the outset. And what we're really talking about is, well, what happens during the employment? And so that's when it becomes so unruly, because, you know, we're kind of predicting all kinds of things that happen during, that can happen during the employment of a general counsel over, you know, their entire tenure. And that can be all kinds of things. And so where do we set the limit? So I guess my question is can we leave it as is, as just here's general guidance on screening, without, you know, really getting into a potential hypothetical, you know, set of facts that may arise during the course of the employment? Anybody?
I think you can.
Just keep it straightforward.
Yeah, I mean, that would be my vote. I actually think this could cause more confusion to go into the hypothetical.
Yeah.
So I guess I'm confused about, so are we talking about just leaving, when you say leaving as is, Cassie, you mean leaving this paragraph starting at 381?
No, I mean, okay, let me go back. Let me look at the screening section again, because I think so. The first paragraph, that's where we kind of get into a potential, what may happen down the road. You know, we draw the conclusion that there's no conflict under 109A or B, so there would be no reason for screening, right?
Right, but one can actually find this part helpful.
This whole set. Okay. However, given that old company and company are competitors with similar technology and patents, a conflict of interest may arise in the future. And then, for example, company may elect to pursue a patent that directly challenges a patent held by old company for technology developed by its employees. If lawyer acquired material confidential information concerning the technology through handling of labor employment matters at old company, then a conflict of interest may arise under, so I just would put a comma after old company under line 368. And then delete under these facts. Put then a conflict of interest may arise under 1.9b, which may be imputed to company's legal department. Okay, then that kind of sets up the whole screening discussion.
And then at the end of that sentence, I just want to address quickly if we add a cite to rule 1.10a, I believe is the cite that would apply there for imputation.
Oh, right.
Or actually, never mind. Now that I see, it looks like you quote it in the next paragraph, so that might be unnecessary. So I apologize. I didn't see that until now that Angela scrolled down. I see that we talk about it following paragraph. So
okay, I forgot. Okay. While lawyers are associated, none of them shall know. Okay, so then we launch into the screening requirements. Okay. Okay, so this is okay. So we're just getting back to. I was just reorienting myself. Okay, hold on one second. Let me just pull up. Yeah, I mean, I don't know. I think this is general enough based on the limited I just think it gets into too much about I don't want to, I think this is sufficient as far as explaining, just based on the limited facts that we have in the beginning of the screening section, for example, company may elect, and that, just based on that, this last paragraph satisfies that, but Sarah, what else do you think we should put?
I agree. And this opinion really isn't focused necessarily on screening, but so because of that, the only thing that I think would be maybe helpful perhaps is, I think you suggested this earlier too, is perhaps dropping a footnote. Therefore, screening may be appropriate, assuming it's timely implemented with the requisite notice to old company at the end of that sentence, adding a footnote to both our rule and then the California Lawyers Association opinion on screening for additional guidance.
Okay. Yeah, good. And then the remaining issue is, do we want to make the legal department bigger, or do you think it's sufficient to say, well, no, since the CLA screening guidance does, offer some relief to those small law firms and presumably legal departments for screening, that we don't really have to make that change. But I think it is still appropriate to say that company may also, I would say here, may instead of also, under line 386, may instead need to refer the matter to outside counsel for handling.
Sorry if I'm missing something here. It says, given lawyers' positions, general counsel overseeing a legal department of just 3 lawyers. That suggests that, those are circumstances. I don't know, maybe it doesn't suggest that. When I read that, I think, okay, only under those circumstances would you need to refer it out. But you could have a situation with a much larger legal department where you still have the same issue. So.
Oh, yeah. So maybe not given. Maybe we don't refer to, we could say something, screening, internal screening may not be possible if internal screening is not possible, or something like that, the alternative is to refer it out, right?
You could say company may also need to consider whether it is more appropriate, or I don't know. I like how you were structuring it. It's not possible, it's not effective.
Yeah, if screening, or if the elements, what are the elements? If the elements of screening cannot be met, then company may instead need to refer.
If screening is not satisfactory, okay.
Angela, can you move that sentence? So delete given lawyer's position. All the way up to the comma. And 3, yeah. And then the sentence that we're writing, put that instead. So put, yeah. If the elements of screen,
an effective screen cannot be met, is that better?
Yeah, if the elements of an effective screen cannot be met, yeah.
I just would suggest a tweak, because we're suggesting that, under the rules of professional conduct here, there are necessarily the elements of an effective screen, when elements of a screen are really, it's discussed a lot in case law, certain elements and they say not every element is necessarily required to make the screen effective. And 1.0.1 in our rules defines screen, right, and what it means. And so I just, by using the term the elements, I think it is I would just word it more generally, if an effective screen
Right.
be implemented,
Yeah, that's good.
or
So if an effective screen cannot be implemented under the rules or just it cannot be implemented, company may instead need to refer the matter up to outside counsel for handling. Okay. Yeah, that's good. Anything else there? Okay. Now here, okay, so you can delete that comment because I took out all the discussion about Chisholm except for what I have here. So I added, so now we're getting into 1.8.1, which is the pecuniary interest adverse to a client and the stock option agreement. So I put here, no California court has addressed whether CRPC 1.8.1 applies to stock or stock option agreements between in-house counsel and their employer. And I'm pretty sure that's correct. I mean, I know that I've done all, I've obviously researched this a lot, so I think that's correct. However, the Washington Supreme Court has recognized that compensation agreements for the in-house lawyer employee, which may include non-monetary compensation. Non-monetary compensation such as computers, cell phones, and health benefits are more akin to standard employment contracts and should not be governed by Washington's version of CRPC 1.8.1. This is a long sentence because typically the lawyer has no advantage in dealing with the client. So remember, Chisholm had to do with bonuses that the in-house lawyer negotiated during the course of the employment. But in the opinion itself, the court addressed it more broadly and talked about non-monetary, in-house lawyer, the fact that if these bonus agreements were considered to be a transaction with a client under 1.8, then then all kinds of other types of non-monetary compensation arrangements between in-house lawyers and their employers would also be subject to review under 1.8. So as examples, they said, if the lawyer is given a computer and cell phone and health benefits, which aren't typical parts of an attorney-client relationship, obviously, but are typical parts of employment contracts. And so none of that, essentially, the court said, should be governed by the rules of the attorney-client relationship, but rather under the rules of the employer-employee relationship. And so I kind of tried to truncate that whole discussion into a few sentences so that we weren't really going into Chisholm, but I really thought that Chisholm's analysis was helpful. So I'll pause there and see if anybody has any questions about this, whether it's confusing, because I wanted to try to distill it as much as possible to the most important part of the case, but I don't know if I did that.
I thought you did a great job of doing that, Cassidy, just from looking at the.
Okay, good. Okay, and then my second site, and then the Washington State Bar actually, the advisory opinion 1045. Unfortunately, it was just a conclusion, so there's nothing that we could have drawn from that, but the conclusion itself lends support to our position here. And then, okay, so ABA task force. Okay, so scroll down. Okay, so this is where I kind of tie in our comment 6, where we talk about, hold on. Okay, so after all these authorities, I wanted to try to bring it back to some kind of authority in California. And so this is where I say this type of compensation arrangement would be similar to, or maybe instead of would be, is similar to a standard commercial to, oops, and then take out A. To standard commercial transactions for products or services that a lawyer acquires from a client on the same terms that the client generally markets them to others, where the lawyer has no advantage in dealing with the client. So that's kind of what we talked about earlier, and we added to the digest. And then the next part is when we talk about the distinction. With Brandon's comment, I took out the discussion about Passante, but I left in the site. I thought it was still helpful guidance, even though I can't remember why. Oh yeah, well, I took out the discussion. I think it's a helpful site. I don't, beyond that, I don't have anything else to say about that. We could take it out, but I don't think it's that big of a deal. I think it just talks about how the lawyer who is, part of advising a company who also took consideration. I forget what it was. Anyway, okay. Okay, so you can take out those comments. And then I added here, thus in determining whether 1.8.1 applies, the in-house lawyer should analyze whether the equity-based compensation arrangement is a standard contract that does not involve an imbalance of bargaining power in favor of the lawyer. And then we go into the factors. Or maybe it should be the opposite.
Do you need whether it's standard or just simply whether it involves an imbalance in bargaining power? It could be kind of non-standard and still not involve.
Well, that's a good question. I mean, it should be standard. I mean, I don't know what's non-standard. I mean, what we're talking about is like if you're treated like an employee, like every other employee, which
right. But employees, I mean, I think it's at least possible that an employee would negotiate this in a way that would make it non-standard, but not because they had an imbalance arising from their kind of legal lawyer-client relationship.
Okay, so will we put whether the equity-based compensation arrangement involves an imbalance of bargaining power in favor of the lawyer?
Yeah, and I think it would be
I think that
wouldn't it be arising from the attorney-client relationship?
Yeah, okay. So yeah, I agree with that. So the in-house lawyer should analyze whether the equity-based compensation arrangement involves an imbalance of bargaining power in favor of the lawyer. Well,
as a
do you want to put as a result of the attorney-client relationship?
Something like that. I mean, I think we should get that down, and if we want to wordsmith it, we can, but I think that's the concept.
Okay, and imbalance by I mean, what we want to say is, does it arise from the attorney-client relationship or from the employee-employer relationship? Which one is the dominant relationship?
Well, they might not even be an employee yet. They might be. I guess in that case, this is less. If you're negotiating your onboarding agreement, but you wouldn't be the lawyer at that point. So
Well, yeah, I mean, like any employee, you can negotiate your agreement. Yeah, yeah. But if, as you know, if it's truly arm's length and you're not advising the client about your own agreement, you know. Yeah. Okay. I mean, I think as a result of
Like, for instance, if you're the GC and you've got an offer to leave and go somewhere else, you know, you might negotiate a non-standard agreement, but that's kind of a based on the employment relationship.
Right. I mean, I'm okay with this language. As a result, or arising a balance of that arises from the attorney-client relationship. How about imbalance of bargaining power in favor of the lawyer? No, I don't even think you need to take out in favor of the lawyer. That arises from the attorney-client relationship, and then put not as a result of, but that arises from. Does that make sense? Or arising from.
I kind of prefer result, but maybe I'm being too, I don't know.
As a result of.
Well, I feel like arising can be a little bit ambiguous, right?
It's not directly tied. Yeah, there's no causal relationship.
Well, of course I'm here, and so it's arising from the fact that I'm your lawyer, but I don't know. It feels a little.
Right. I think that's right. As a result of. As a result of. Yeah, I mean, I think that makes sense as a result of the attorney-client relationship.
Okay.
Okay, and then so those are the factors. Okay, so let's move down. There's a more kind of substantive question. So I added, okay, so if it is determined that 1.8.1 applies, then the requirement of 1.5, which governs the reasonableness of fees charged by a lawyer, must also be satisfied. It actually governs the unconscionability. It's not really reasonableness. However, this analysis is subsumed within the first prong of 1.8.1. And this is from that ABA opinion. In determining whether 1.8.1's first requirement of fairness and reasonableness to the client is satisfied, the general standard of 1.5a that a lawyer's fee shall be reasonable and the factors enumerated under that rule are relevant. And I think we kind of touched on this before. You know, this really isn't a opinion. This is a conflicts opinion, not an opinion about reasonableness or unconscionability of fees. But, you know, I think it's interesting and probably worth noting that, you know, for the same reason 1.8.1 wouldn't apply to an employment agreement, you know, with stock options, 1.5 probably doesn't apply to wages, you know, which is how the Chisholm court characterized the in-house lawyer's compensation.
I agree. I think it's worth a note.
And it's just this paragraph that I added. And then I put in the footnote. So if you go down to footnote 9, I put analysis of 1.8.1 is and 1.5a is beyond the scope of this opinion. So in other words, that 1.8.1 discussion is just whether it applies. You know, whether or not the elements are met is a different analysis, or not a different analysis, but not covered by this opinion. And 1.5 is not covered by the opinion. So I don't know if that's confusing or not. I didn't want to get into I didn't want to get into a 1.5 analysis, frankly, but You know, if there's a decision that 1.8.1 applies, then, you know, we're not getting into, is it fair and reasonable? You know, is it, because that's not the facts here. You know, if the facts were like, fair versus, but, you know, where it's, you know, the lawyer is part of the company formation and is, you know,
Right.
it's not, you know what I mean? So but I just wanted to make sure this made sense, to kind of dodge this issue in this way. Or should we just take out reference to 1.5 altogether?
I have an unavoidable conflict. I'm gonna have to jump off for about 15 or 20 minutes. I'll be back as soon as I can. As I look at this, I'll just give you my comment before I have to jump.
Oh, that's okay.
I like it. I think it's helpful because I think some people will have the question, and I think it's helpful to have it. I would vote in favor of retaining it.
Okay.
That's it.
All right. Well,
For public comment purposes, I think more may be better, and then you can get feedback on whether or not you think it's the public thinks it's
confusing
applicable or not. Yeah.
Okay. All right. I mean, so thanks, Eleanor. So it's clear enough, at least to pass muster that for this first phase. And so, well, let me ask you this, Erica. I mean, you know, not that I want this to go through any more significant revisions, but after the public comment phase or the first public comment round, even if there's no public comments on this, can we still wordsmith a little bit more? Are we allowed to make changes? Or are we only,
Yeah, there's nothing that would preclude that. That being said, if you do that, you may have to have another public comment. So
right. I mean, I'm figuring what we'll probably have 2 rounds of public comment. So you know, I guess I just want to see what the public thinks. I want to get it out, see what the public thinks about this. And then, you know, we still have the option of tightening it up a little more. I mean, it's never done in my mind.
Sure.
Okay, so go ahead.
I was gonna say, I'm not sure if you're done with the things to go over, but if you are done, I did find the answer to that question we had about the substantially related comment.
Oh, good. So an opinion that talks about. Yeah, you want to.
It's an so COPRAC has an imputation opinion that I think you've cited in this, I would assume, already, which is I'm gonna send and the text that I quickly pulled together, but it's opinion number 1998-152, and it talks about like the difference between discipline and disqualification to some extent. Obviously that was it's an old opinion, so it's under the 3310 analysis before there was everything that's in 1.9 and 110. But I do think that part of the opinion is still relevant. So I just sent Ange some language that I think that perhaps would make sense as a footnote.
Okay.
Additionally, I think in that section, it's still that however sentence, which I have the old numbering that I'm looking at. So
just give me a ballpark so I can scroll up.
Yeah, no problem. I think it's in like the 200s section. It's line 241 on my mine.
Okay, right here.
Yeah.
Oh, so I'm sorry, did you put the?
Yeah, it's in blue now. That's the
Okay.
Something that could be added as a footnote. Obviously, with edits.
I also think Rule 1.0 and the comment
Yeah.
about the purpose of the rules might be a good site to add in addition to the COPRAC opinion. And I know
Agree.
there's also the last comment to the imputation Rule 1.10 that also, I forget what it says exactly, but something about standards for disqualification and whether screening's effective are also developed in case law in addition to the rules. There's something like that in a Rule 1.10, the last comment to it, which I can pull real quick. It's
Yeah, I can send that to Ange too. It says standards for disqualification and whether in a particular matter a lawyer's conflict will be imputed to others in the same firm, or the use of a timely screen will be effective to avoid that imputation are the subject of statutes and case law. I think you could just put C COPRAC opinion and then Rule 1.0 and then 1.10 comment 6 as the site, and that would cover it without getting too much into it.
agreed.
Yeah.
And then I think that you could also slightly tweak the first sentence of that paragraph.
Is this a full quote? No. Okay, wait.
No, there's the only the first sentence is a quote, and then the rest of it is just paraphrasing what's in the opinion, essentially.
Okay, so you want to tweak the which first sentence?
Oh, I'm sorry. On line 244.
Mhm.
I think the issue here is disqualify a lawyer under 1.9b, because you don't disqualify under 1.9. You violate 1.9 and then may be disqualified, or you're disqualified and may violate 1.9. It's two separate issues. So maybe clarifying that would solve it. So if you just said it's not enough to disqualify a lawyer or violate Rule 1.9.
Oh.
Would that help? Do you see what I'm saying?
Yeah, I am. I'm just thinking. But have they actually have courts found that? Yeah, I mean, I guess or violate.
It wouldn't be the Fremont site there if we're talking about 1.9, although I don't know if it addressed the former rule.
Right.
Yeah, I think you would do a string cite of all. I would just add that's a string cite, isn't it? It's C Fremont and then Victalic and Wu. I think you would just add Rule 0.9 to that string cite.
So take out okay, wait.
So it'd be courts have found. Well, I think you'd have to get rid of the courts have found. However, knowledge of a company's general business practices or philosophy alone is not enough to disqualify a lawyer or violate Rule 1.9.
Okay, so take out courts have found. I see what you're saying, Erica. Okay, and then just what or violate put or violate CRPC 1.9b. So you can take out Rule 1.9 and under. And rule. And I would put a period. Wait, so put a period there.
I think, yeah. And then with instead,
capitalize.
You could have critical importance in quotes, and then you could also add what's in 1.9. You could just have material. I don't even know if you need the quotes. You could just say material or of critical importance, and then cite Rule 1.9, and then have all those case sites. Does that make sense?
Where do we have material? Okay. So instead, there must be a showing that which gained from the playbook is of critical importance or material right there,
Yeah, or is material.
or is material to the matter at hand, and then C,
Rule 1.9 and Fremont.
yeah. Put CRC, I mean, I don't know, are we gonna change the sites to that?
Staff will at some point, but
Okay.
I
Just
don't
like,
know
yeah,
if it's
so
before this, yeah.
okay, so put, yeah, so is it 1.9? It's just 1.9.
It's
It-
B2,
it's not-
it's B2 technically.
Okay.
Yeah.
B2. And then semicolon Fremont. Yeah. And then period and after 65 there in Fremont site. Okay, that's good. And then and then the footnote at the end of all that. Okay. And then potential, okay, so we can scroll down all the way to the end. We're almost done. And go down to like 490 something, 496 or so. Or go down to, no, keep going, sorry, I'm way off. Go up, you can delete that, what did I say there in that highlighted yellow? Yeah, you can take that out. Okay, so I didn't have any other changes. And that's it, let me see. Okay, so yeah, I didn't have anything else here. Does anybody have anything about 1.7, the discussion under 1.7? Going once, going twice. Okay. Well, I'm done with this. I don't know about anybody else. What's the next? I mean, I'm happy to vote this out. I don't know if it's totally ready. But I'm happy to get it out there if unless anybody has any qualms or issues.
Do we have our quorum?
Yes, now that you're back on screen, we do.
Okay.
I would just add that when you if you are going to vote it out, I would strongly recommend, with all of the changes today and with the numbering, Cassie, that you mentioned, that you direct staff to make style conforming changes essentially.
Yes. So with the I recommend I move that we
Yeah.
voted out. Yeah, and with the changes that we made today and with the qualification that staff will make non-substantive stylistic revisions to the headings and anything and citations that are necessary.
Seconded? Can I second?
Yes.
Okay, I will take the vote. Brown? Did you have a question, Elizabeth?
Nope.
Okay, sorry, I thought I saw your hand. Bradley?
Yes, approve.
Shivers?
Yes.
Guzman? Mark?
Yes.
Mercado? Munoz?
Yes.
O'Reilly? Dexter?
Yes.
Robbie? Starr? And Krieger?
Yes.
Okay, so the motion carries. 1, 2.
Yay.
And I apologize now. I need to step out of the meeting now. And I want to thank everyone for their hard work on this, especially Cassidy. And in advance, I want to thank Joel for his excellent work on the flat fee issue that I will not be around to talk about. But thank you all. Everyone have a great weekend.
Thanks.
You too, Brad.
Thanks, Brandon.
Bye.
Thanks. Okay, so I guess it's me, huh? So Joel, are you ready to talk about the flat fee? See, I'm already, what's it called totally? Flat fees and termination.
Right.
200003.
Yeah. Let me go over the history. This is something that I think we might have even started back in the mandatory fee arbitration days, but particularly after 1.15 was adopted, it changed the ballpark because we had to address the issue of whether or not the flat fee can be taken into the general account or to the trust account. And you look at the language of 1.15, it says that it can be done into the general account with written consent. It's not entirely clear what that means because it didn't say informed written consent. And I've always thought that informed written consent is kind of redundant anyway, but we tried to clarify that a little bit. And particularly the problem is that when a flat fee, which we now know is subject to refund if all the services are not completed, is deposited into a general account, that money is available to all of the attorney's creditors, and there may not be a ready source of refund if all the services are not performed, and particularly when the attorney might be in financial trouble anyway, that increases the odds of the attorneys completing all the services. But so we had to kind of deal with that, and Ken took the lead. He kind of laid it all out. And when he dropped off the committee, I took it over, and I just had this myriad of different drafts with red lines and comments from people. And finally, for my New Year's resolution, I tried to reconcile all those drafts and make as many additions and considerations of the comments as I found. And what you have is as far as I got. What I'd really like to do today is, number one, in Ken's draft, there were just a number of different hypotheticals, which you see are left in following my recommendation.